Morning.
Wait, please, Your Lordship.
Yes, please.
Yes, my Lord, I beg to mention item number 6 of Your Lordship daily list, my Lord. I filed an additional affidavit in this writ petition on day before yesterday, on Wednesday, my Lord.
As prayed for by Mr. D. Goswami, learned counsel for the petitioner, which is consented by the other side, list this matter again on
next Wednesday, my Lord, 21st.
on such and such date. You have filed something?
I have filed an additional affidavit, my Lord.
Let the additional affidavit filed by the petitioner be brought on record by the registry.
Maybe I beg to mention item 9, my lord. It has become infructuous.
9.
Yes, lord.
9 has become
Infructuous. Petitioner expired and he has got the benefit before his death.
Right. Your name?
B. Purkasta.
Heard Mr. B. Purkasta, learned counsel for the petitioner. Also heard water resource. Anyone?
RM Das.
Also, but he is not here. Mr. Chutia, you are there?
Yes, I am.
Also heard Mr. T. Chutia, learned
State respondents.
Additional senior government
Senior government,
advocate for the state respondent. Stop. Mr. B. Purkasta submits that the matter has become infructuous in view of the fact that the petitioner has received the
All
benefits claimed under the instant writ petition, and after that the petitioner has also expired. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, the matter is dismissed for being infructuous.
Obliged, lordship.
May I please, your lordship? Lordship, I beg to mention item number 11, lordship. The matter become infructuous.
Infructuous.
Lordship.
Your name?
D. Datta.
Heard MS?
D. Datta.
D. Doctor.
Lordship.
Your name is not on record.
I am appearing on behalf of Mr. P.J. Soikia.
Heard MS?
D. Datta.
D. Doctor, learned counsel, appearing on behalf of Mr. P.J. Soikia for the learned counsel for the petitioner. Stop. Also heard excise?
I Kolita.
Mr. I. Kolita, learned standing counsel?
Yes, sir.
Excise department. Stop. MS so-and-so, learned counsel for the petitioner, submits that the matter has in the meantime become infructuous. Stop. In view of the aforesaid endorsement, the writ petition stand dismissed for being infructuous.
Obliged, lordship.
Please, Your Lordship. Lordship, I'd like to mention item number 39, Your Lordship.
Item number?
39, Your Lordship. The concern of the other side has already been
One
taken.
second. Hey, Priyanka, হেৰিকেইটা check কৰি ল'বা অনলাইনত ঠিকে আছে নে নাই volume voice 30 কিমান কৈছে
39.
That is an order matter. Order
Yes, sir.
matter, please wait for your turn. No mention for orders. Just wait for the turn. Yes.
May I beg to mention item number 13?
1-3.
Yes, Lordship.
Yes, what do you want?
Can this matter be fixed after a week, Lordship?
Why?
Lordship, that recent instruction we haven't received.
You are for
I'm for the PJ Fukan. On behalf
item
of PJ.
13.
Yes, Lordship.
PJ Fukan's name doesn't appear in the list. 1C.
SCGU.
This
SCGU.
is not for the petition.
Yeah, for the petitioner.
Matter relates to release of family pension. So, notice was issued in 2019. No affidavit has been filed.
Then we will see when the matter is
Yes,
called.
Lordship, and I beg to mention item number 44. Lordship.
44 is a order matter?
No, Lordship.
Order? Yes, call for the list.
Order no steps at all.
ইয়াত এখন লিখি দি দিব লাগে আছে Yes, who's appearing for the petitioner? None appears? None appears for the petitioner when the matter is called. Mr. A. Ganguly, learned counsel for respondent numbers 1 to 5 is present. It appears from the cause list that the petitioner has not taken steps for service of notice upon the respondent number 6, despite repeated directions of the Lawazima Court's order dated 25/24, 35/24 and 7/6/24. Stop. Today, when the matter was listed under the column within court order no steps, comma. Neither any steps have been taken, nor there was any representation on behalf of the petitioner when the matter was called. Stop. In view of the above, the writ petition stand dismissed for non-prosecution.
Okay.
Disposed.
May I please, Your Lordship?
Yes, Aganwadi.
Yes, Lordship.
No affidavits filed till now?
No, Lordship.
Yes. Everyone is represented.
Lordship.
Who's appearing for R6?
Lordship, myself.
Yes.
I need 2 weeks time to file my reply.
All right. Your name?
I Ahmed.
Mr. I. Ahmed, Learned Counsel for respondent number 6, 2 weeks time to file the counter affidavit in the matter which is not opposed by the other side. List the matter after 2 weeks on a date to be fixed by the registry. Yes, reply filed?
My lord, filed.
Filed?
Yes, Lordship, kindly pass over the matter for time being.
Pass over the matter for the?
Time being.
Why?
My senior is unlike in another.
Your senior is behind you. Yes.
My lord, this matter pertains to VRS benefits, my lord. My lord, the petitioner is ex-employee of Assam Cooperative Sugar Mill Limited, my lord.
Why are these benefits not released?
Lordship, they have received the amount, Your Lordship. I have stated in my affidavit, Your Lordship. The petitioner have received around 15 lakhs after the liquidation, Your Lordship. Now the claim of the petitioner is that he is asking for, as per the new ROP, the calculations. But that is not permissible at the point.
So there is some dispute.
Yes, Your Lordship.
Yes, my lord. My lord, my grievance is that, my lord, the calculation for the VRS benefit has been made, my lord, on the basis of the scale of pay which was existing at that in the year 1988, my lord.
All right, just 1 second. Just take me to those 2 relevant paragraphs. One where the objection has been raised by the respondent in their affidavit in opposition. Which paragraph? Yes. AO by R5.
Lordship.
R5, you are for R5?
Yes, Your Lordship.
Yes. Which paragraph have you said that? Are you all not prepared?
Lordship. Lordship, paragraph number 10, Your Lordship. Their calculation has been done as per Sugar Waste Board 3, Your Lordship. Paragraph number 10 of my affidavit in opposition.
Read.
That with regard to the statements made in paragraph number so and so of the writ petition, the deponent begs to state that it is not a fact that the Sugar Waste Board 3 was in existence till 1989. In fact, the Waste Board commenced from January 1989 and would exist for another 10 years. Furthermore, the deponent begs to submit that the petitioner has admitted that the government of Assam does not possess any Sugar Waste Board and had not revised it. It may be mentioned herein that the chairman and the secretary of Senikol Kormosari Homonai Committee, who was also the petitioner in WPC number so and so, gave an undertaking to the effect that the association will accept the payment as per Sugar Waste Board 3, and they will not insist to the effect of Sugar Waste Board 4. The deponent further begs to submit that regarding appointment of the chartered accountant by the Honorable Guwahati High Court in WPC so and so.
Where is the reply to this paragraph?
Yes, my lord. I have replied in my preliminary reply, paragraph 8, at page 67, my lord.
Yes.
My lord, here I have stated that with regard to the paragraph 10 of the
So
affidavit in opposition-
some deliberation would be required in this matter. I'll admit it. This is item number 3.
Yes,
My
Your
lord, can it be fixed in admission in another day, my lord? For
No.
disposal, my lord.
We'll give you a short date. Heard, Mr.
I'm sorry, my lord.
M. Saikia, Learned Counsel for the petitioner. Stop. Also heard, Mr.
G. Bordeloy.
G. Bordeloy, Learned.
Standing Counsel, Co-Person.
Standing Counsel, Cooperative Executive
Corporation.
Corporation Department, and Mr. N. Kalita for respondent number 3. Anybody else? Stop. The matter needs the writ petition requires a full-fledged hearing, admit no formal notice, list for hearing September on such and such date.
17 September.
Apply Jalochi.
4 and 5.
In this matter, we have already filed affidavit, my lord.
Yes. Salary.
Item number 5.
Mr. Bosa, have you received the salary or not?
No, madam.
No salary
Madam,
received.
only salary, madam.
Why salary is not paid?
Madam, very sorry state of affairs, madam.
Affidavit not filed, Mr. Chutia?
We have filed, my lord.
Madam,
No, in the
Item number 5, my lord.
item 4 affidavit is not there.
No,
madam, item
Five.
5 may be taken up first.
Take it up first. We
Madam,
have
that
filed
will
Yes,
solve
Mr.
the
Bosa.
problem, madam. Madam, here, madam, 3 affidavits were filed
Yes.
by the respondent number 1, respondent number 3, and respondent number 7.
Yes.
Yes, my lord, my lord, what happened, my lord? In 1993, prior to 1493, the petitioner was engaged as casual employee. And then,
When was it petitioner appointed, you said?
93 February, my lord.
Okay.
And thereafter, my lord, what happened? He approached this honorable court, and in 2005, a direction was issued by the honorable court, my lord. That is in page 37, annexure 3. A clear-cut direction was issued, my lord, at page 39. Relevant is at page 39.
So you had filed for regularization,
My lord.
at that time.
My lord.
The court's direction was to consider the case of the writ petition as
My-
per policy decision.
My lord. Then what happened, my lord? The petitioner was appointed as peon, my lord, by order dated
Page.
by order dated page 46, order dated 14/09/2015.
He was appointed as a peon.
Peon,
Yes.
my lord. Thereafter, no salary was paid to the petitioner. That's why the earlier case number item 4 was filed. Then thereafter, what happened, my lord? The impugn order was passed, which is at page 58, annexure 11.
Yes.
This is the order dated 10th November 2010. Here, my lord, the 2020, my lord.
10/11/2020.
Yes, my lord.
Yes, please.
Relevant portion is at page 59,
Yes.
paragraph 3. Before that, my lord, what happened, my lord? The director issued letter to the state government as well as the finance department to release the salary. Upon receiving that letter,
This order has
the
been passed.
department has passed this order. Joint Secretary, my lord,
Mr.
of the
Bulsa,
state.
read this
Here he said that appointment is null and void.
Anyway, you read this order and you can go slow.
My lord,
There's no difficulty.
paragraph 3, my lord.
Yes.
There is no policy decision of government to regularize the service of any casual employee appointed prior to 1/4/1993. The proposal for regularization of the service of so-and-so should not be considered, and the appointment letter issued wide order dated 14
Where is
October.
the appointment order? Page 46, correct?
My lord, my lord.
Let's see the appointment order. This appointment was pursuant to the direction passed by
My lord.
this court. Isn't
My
it?
lord, my lord. Yes, my lord.
Yes.
Annexure 5 at page 46, my lord. That is, that was passed after 10 years of the order issued by your lordship, by this court, my lord. Which
And all this while you've been working, Mr. Bosa?
yes, my lord.
You have been working.
I am working.
Is there any dispute to that?
and honorary salary is being paid to me,
But regular salary is not given.
not given.
How much is the honorary salary?
9,000.
9,900.
9,000. May I read, my lord?
All right. This appointment order otherwise looks valid. Yes.
Yes, my lord.
Now, what is their stand? The stand is that there was no policy decision. That
My
is the
lord,
stand.
Yes.
my lord, that
But then, how did the appointment come?
My lord, that's
What
why,
is
my
your
lord.
justification
Lordship, kindly see
for the
our affidavit, my
appointment?
lord. Our affidavit filed by respondent number 1.
Yes.
State paragraph 5, my lord.
Yes.
Page running page, I think
Affidavit
72.
filed by respondent number
1. Secretary, Social Welfare Department. Running page 72.
1 second, Mr. Running page
72.
72. 72 is one notification of no, not 70.
Oh, 70, my lord.
70.
70. We start for second 70.
No, I think there is some change in the.
Maybe, my lord, yes.
Anyway, 1 second. I'll find it out.
Gauri-Shankar Sharma.
my lord,
Got it.
Got it.
4424 filed on.
4424, my lord.
Yes.
Yes, ma'am.
Paragraph?
Paragraph 5.
Yes.
May I read it, my lord?
Yes.
With regard to the statement so the backs to state that the Social Welfare Department, now Department of Women and Child Development, received a letter from the Director of Social Welfare by letter dated 16/2/2016 requesting to move the Finance Department for approval of fresh appointment of Sri Baharuddin Loskar as per appointment order issued by the Director of Social Welfare by letter dated 14/10/2015. However, the proposal could not be
1
forwarded.
second. But what does this mean? Because he was already appointed on 14/9/15.
That was erroneously. That's I am coming to the
No,
last
after
part.
this, then how in paragraph 5 you are saying received a letter
From Director of Social Welfare.
to move finance for approval of fresh appointment?
Yes.
Before issuing this letter, there must be something.
Yes.
Where are those?
That's why, my lord. Next paragraph, my lord. However, the proposal could not be forwarded immediately as various documents records were required along with the proposal, and thus several correspondence were made with the Director of Social Welfare. Ultimately, the proposal was submitted to the Finance Department SIU Department on 6 October 2018. The Finance Department wrote the proposal through control branch on 10/6/2020. Thereafter, Finance Department EC Department was requested to accord concurrence to the proposal. This paragraph also can see. The Finance Department communicated its observation that there is no policy decision of the government to regularize the service of any casual employee appointed prior to 1/4/1993. The proposal for regulation of service of Sri Baharuddin Loskar should not be considered, and the appointment letter issued on 14/10/2015 is declared null and void, and the hiring official who issued appointment letter to Baharuddin Loskar without approval of the Finance Department should be booked, and the department is requested to take action against the officer. According to the Director of Social Welfare, Assam was intimated the observation made by the Finance Department.
What is the role of the Finance Department?
Finance Department, without any approval of the Finance Department, any post cannot be filled up.
So, before giving appointment, for approval has to be taken from the finance.
Required.
Mr. Nayak?
Be it direct
Nayak,
recruitment,
huh?
yes, be it direct recruitment or regularized.
Regularized.
Any appointment, first an approval has to
Approval of
be
the
sought.
Finance Department.
So here, after the court's direction on 19/1/2005, right, Mr. Boystock?
My lord.
So after that, no communication was made to you, and straight away an appointment was issued on 14/9/15.
Prior to that, one page 47 is there. The petitioner made an application, Lordship. He simply stated that one post of grade 4 is lying vacant, so he should be considered for regularization of his service against that post. And
Yes.
the director immediately regularized his service without taking any approval later from the.
So therefore, there was one post available. Now suppose it's a case where your approval has not taken, you can always give a de facto approval.
No.
What is the difficulty?
The policy of the state government is after 1/4/1993, nobody has been regularized. There is no such policy of the state government, and that policy was challenged before the Honorable Division Bench in the judgment of Ukam WF 45 of 2014. Here it has been decided, the matter was decided by the Division Bench that no direction can be passed, even if he is appointed prior to 1490.
Well, Mr. Boyce, I'm admitting these petitions.
My
There is no point of keeping this petition pending in the admission stage. I'll admit it and post it for hearing in September.
only thing
Since
is,
all the pleadings are completed.
Yes.
my lord, only one thing, my affidavit in reply may be considered.
That's
Similarly
all right. I'm
situated
admitting it,
persons,
Mr. Boyce.
my lord, similarly situated persons
Heard
were
Mr.
given.
G. Bursar, learned counsel for the petitioner, stop. Also heard Mr. T.C. Sutia, learned additional senior government advocate for the state respondent, and Mr. P. Nayak, learned standing counsel, finance and finance. Stop. It appears that the pleadings are completed in the present writ petitions. In the present writ petition. Stop. It further appears that a full-fledged hearing is required. Admit no formal notice. List September date deliver on such and such date for hearing.
12 seconds. Obliged, deeply obliged.
12 seconds. Obliged, my lord.
Yes,
Made to
Mr.
your
Dekka.
Lordship. Lordship, in this case, Lordship, I had initially during the time of filling up the form, I made an inadvertent mistake
Filling up the form for what?
for the post of ward boy.
Yes.
What has happened? I have put in yes instead of no in the column which says physically handicapped. Physically handicapped.
So you said no.
I said yes.
Yes for physically handicapped.
Yes.
But you are actually not physically
No.
handicapped.
No. Then, Lordship, during the time of the examination of verification of documents and also during written, I have intimated the authority that this is the
This
mistake
was a
which I
mistake.
have committed. So, what to do? They said nothing will happen. You just give your normally. Lordship, may kindly see the calling letter for verification of documents. Lordship, at page number 17.
But Mr. Dekka, you should have given a clarification in writing.
Yes,
The serious mistake, you see.
my lord.
Yeah,
My lord.
that should have been on writing. Yes,
But
page.
my lord, in page number 17, list of documents required to be furnished in original.
Yes.
It says admit card, academic qualification, age proof certificate, employment exchange registration card. So these are the 4 documents required. And that means I have not been considered as physically handicapped because no certificate of that has been called from me. Now, what be that as it may, I have appeared and I have given written and also viva, and then I was appointed. Now,
You are appointed.
yes. After that, I have joined the services on 16/7/2018. I had worked for 5 months. Suddenly, I was called to the office of the director. Said, "You bring all your documents." I brought the documents.
You
and in
when
seven-
your appointment was to which post? Was it considered as a reservation?
yes, it was considered as a reservation.
So you were considered as a physically handicapped person.
Yes, Lordship. That is
If
according to
that
the
is
impune
so,
order.
then of course there is an error.
Yes, Lordship.
Lordship, that statement, Lordship, I have made in my affidavit, Lordship.
Where?
No, that is not my
Mr.
contention.
Upadhyay, right?
Upamanya.
Upaman. Mr. Upaman, just give me 1 minute.
Yes.
Mr. Dekka, where is that?
I have-
Where is that? You're challenging what? The termination.
Yes, Lordship. Lordship, my thing is that, Lordship, I am not saying that I.
Where is the appointment?
My appointment, Lordship, is on page number 22. 20.
What is this 19?
Same, Lordship. This is the order, Lordship, that I have to join within 15 days.
Where is it say that it is against physically
No, it doesn't
handicapped?
say. It doesn't say. This I have come to know from the impune order, not before that.
Where is the impugn order?
Impune order, Lordship, would find at page number 24. Whereas pursuant to the above advertisement, above 2 candidates applied for post of ward boy through online under 3% reservation quota of PWD as per provisions made in the advertisement.
Yes, please read.
Yes, ma'am. Whereas the above two candidates submitted their application in which they have stated in respect of column that they are physically handicapped person. They were also selected by the selection committee on the basis of their merit and accordingly issued appointment order as noted against each above. Whereas after re-verification of the appointed documents, it has been found that the age
You
of
are Jogesh Bejbarua.
Jogesh Besbarua. Whereas again, though Jogesh Besbarua has applied under 3% reservation quota of PWD by filling up the respective column in application, no copy of PWD certificate was
PWD mean?
Person with disability.
person with disability certificate have been found enclosed with the application of Jogesh Besbarua. As per the appointments have already been made, the above two appointees have been directed to appear before the undersigned being the appointing authority with their PWD certificate issued by the authorized medical board. Accordingly, the above two appointees appeared before the DHS Assam on 27/11/18 and 3/12/18.
Yes.
Yogesh Besbarua failed
All
to
right. Then what is wrong in this order, Mr. Deka? You have made that mistake. Where on writing have you clarified?
my humble submission, Lordship, I have understood.
No, you are seeking. It is you who wanted this appointment. You are expected to be more careful while filling up the form. All right. Sometimes mistakes can happen. We are human. Mistakes can always happen. But then, what have you done? Where is it on writing that you have clarified?
On writing, it is not there,
Then-
Lordship. But during the time of examination, it has been stated, and the
On
verification also.
record anywhere, from anywhere, you can show that you have communicated.
My case is that, Lordship.
Mr. Upamanyu, what is your stand?
Lordship, since he has applied for the PWD candidate, Lordship, and he was appointed accordingly, Lordship, for unreserved category, Lordship, he doesn't qualify because the cutoff mark was 90 marks and he obtained, Lordship,
Where is your stand in the
Lordship,
affidavit?
at page, Lordship, I do not have the running page, Lordship. It is page 4 of my affidavit in opposition, Lordship. Para 13, Lordship. Para 13, Lordship. May I read?
Yes, please.
That as regards to the statement made in paragraph number 15 of the writ petition, the deponent begs to state that the petitioner did not get selected for appointment under non-person with disability category as his mark, that is 71 marks obtained in the list, was below the cutoff mark from the unreserved category, that is 90 marks, and was appointed against the 3% reservation quota. Hence, the appointment of the petitioner was cancelled by its speaking order dated 10/12/2008.
Yes. Anything else? All right.
Page them, Lordship. And one more thing, Lordship. I have worked for five months. The salary should be given to me, Lordship, for the working of that 5 months.
All right. This is item number
7, Lordship.
heard Mr. P. Deka, learned counsel for the petitioner. Stop. Also heard Mr. D. Upamanyu, learned standing counsel, Health Department for the respondent. Stop. This petition is filed under Article 226 of the Constitution of India, seeking inter alia quashing of the speaking order dated 10/12/2018, whereby the petitioner's appointment to the post of ward boy
Ward boy.
was cancelled. Stop. Speaking order bearing number so and so, dated 10/12/18. You will get it on page 12. Stop. The case of the petitioner is that pursuant to the advertisement dated
16/7/2018.
16/7/2018.
No, Lordship.
Huh? Advertisement is
16/7/2000.
16/7.
no 16/7 is your appointment, correct?
This advertisement dated 16/12/2017.
Where do I get it?
Page number 14.
All right. Pursuant to the advertisement dated
16/7/2017.
16/7,
2017.
2017. For filling up vacancies under the establishment of the Directorate of Health Services Assam, comma, the petitioner applied for the post of ward boy through online under 3% reservation quota for person with disability as per provision made in the said advertisement. Stop. Thereafter, the petitioner along with another candidate, no, only petitioner was
Yes.
Thereafter, the petitioner,
Lordship, his application is at page 15, Lordship.
Called for document verification, Lordship.
thereafter the petitioner was appointed after due selection and verification
Of documents.
of documents by order dated 16/7/2018 to the post of ward boy and was accordingly posted in Lakhimpur Civil Hospital. Stop. It is the further case of the petitioner that pursuant to such appointment, he resigned from the work where he was previously working and joined the new post on 16/7/2018. Stop. Accordingly, he was performing his duties to the full satisfaction of the respondents, and after more than 4 months of service, he was asked to furnish documents for
Re-verification.
Stop. Thereafter, by order dated 10/12/2018, the Director of Health Services Assam issued a speaking order bearing number so and so dated 10/12/2018, whereby the appointment of the petitioner was cancelled on the ground that the petitioner was appointed against 3% reservation quota for persons with disability within bracket PWD at the newly created model hospital. However, the petitioner was not a person with disability. Stop. Aggrieved by the aforesaid speaking order dated 10/12/18, the present petition has been filed. Stop. Mr. P. Dekar, learned counsel for the petitioner, admits that while filling up the application form for the post of ward boy pursuant to the advertisement dated so and so, it was inadvertently ticked
As yes.
as yes against the column person with disability. Stop. He further submits that during what stage you clarified?
During the time of submission of documents.
He further submits that during the stage of submission of documents, the petitioner verbally clarified to the respondent authorities that it was inadvertently mentioned as person with disability, though he is not one such. Stop. However, the respondent authorities told him that however, the respondent authorities assured that
Lordship, in paragraph number 7, I have written.
you have mentioned.
Page 5, paragraph.
Yes, I've got it. However, the respondent authorities did not raise any objection. Stop. He accordingly submits that the aforesaid mistake being inadvertently done, the same may be condoned and the impugned cancellation order be set aside and quashed. Stop. Mr. D. Upamanyu, Learned Standing Counsel so-and-so, on the other hand, submits that since the petitioner is not a person with disability and he has been appointed against the reserved post for person with disability, comma, the impugned cancellation order is valid and warrants no interference from this court. Stop. I have given prudent consideration to the arguments made by both sides and have perused the documents on record. Stop. It appears that the petitioner, while filling up the requisite form for selection for appointment to the post of ward boy pursuant to the advertisement dated so and so, comma, opted yes against the column for physically handicapped,
Person with disability.
for person with disability, and after selection and verification thereof, he was appointed against such reserved post. Stop. However, upon detecting that the petitioner got selected for appointment under person with disability category, comma, the respondent cancelled the appointment. Stop. It is observed that there is no written communication given by the petitioner clarifying the said position before the respondent authorities at the time of selection or pre-appointment to the post of ward boy. Stop. Though it appears from paragraph 7, which is reproduced hereunder for ready reference, page 5, paragraph 7, A to A, that the stand of the petitioner is that the petitioner had verbally informed the respondent authorities. However, the respondent authorities did not raise any objection. Cannot be accepted by this court inasmuch as they said, you have denied this?
Yes, please.
Inasmuch as the said averments made in paragraph 7 has been denied by the respondent authorities in the affidavit in opposition filed on 26
26.
Is it 26?
Yes, Lordship. 26.
26/3/2021. Stop. Paragraph 8 of the aforesaid affidavit in reply is reproduced hereunder for ready reference. A to A, page 27. Running page 27, huh? Paragraph 8. Paragraph 13 also is reproduced here. Paragraph 13 of the affidavit of the said affidavit in reply is also reproduced herein for ready reference. Paragraph page 28, B to B. Since the appointment of the petitioner was cancelled, as the petitioner was not appointed against the reserved, was not appointed against an unreserved category, comma, this court finds no illegality or infirmity in the impugned cancellation order dated 10/12/2018. Stop. Therefore, this writ petition has no merit and fails. However, considering that the petitioner had worked for few months upon being appointed to the said post of ward boy, and after joining in the said post, comma, the respondents are at liberty to consider the application to the representation made by the petitioner for release of salary for the said period.
For the period of employment.
For the period of employment. Stop. All right.
Lordship, after due verification, Lordship.
After due, stop. Needless to clarify that as and when such application is made, the respondent authorities, upon due verification, shall do the needful within a period of 3 months from receipt of the representation. Disposed of. Dismissed.
Highly applied.
Promotion.
Lordship, one increment was
Reply
stopped.
filed or not filed?
No, Lordship.
You will file?
Yes, Lordship.
Your name?
I am MP Sharma.
Mr. MP Sharma, Learned Counsel, for the petitioner seeks 2 weeks' time to file reply against the affidavit in opposition filed by respondent number 4.
Yes.
Prayer allowed. List after 4 weeks on a date to be fixed by the registry.
Otherwise, Lordship.
Regularization. None appears for the petitioner when the matter is called. Stop. Mr. N. Upadhyay, Learned Standing Counsel, Irrigation Department, is present. List this. This is a pensionary benefit.
Lordship, he was not regularized, Lordship. And once he is not regularized, he is not entitled for pension. He was
List this-
appointed after 1493,
List
Lordship.
this matter after 1 week on a date to be fixed by the registry.
Lordship.
Yes.
May your lordship be please
Affidavits not filed.
Affidavit not filed, Lordship. It is a settled law, Lordship. The petitioners were appointed against personal post, Lordship, and they are not entitled for promotion, Lordship.
matter may be passed over for the day.
List again on such and such day, Monday, Tuesday, Wednesday. All
Obliged,
right.
Lordship. Item 13.
This is that matter where I think a mention was. Where is the respondent gone now? Respondent was trying to make a mention.
Yes, my lord.
So 19 matter, no affidavits filed.
Yes, my lord.
Which one? Who was trying to make a mention in the morning,
My
Mr.
lord,
Sharma?
TJ Fukan, my lord.
Huh?
Representing TJ Fukan.
Where are they now? Guwahati University. Yes.
May I pray an adjournment for the time?
For what? This is a 2019 matter.
Yes, Lordship, we have to receive recent instruction.
So say that. Why can't you be more appealing to the court? If you have received instruction, say that you have received instruction and you say that you want so much time to file the affidavit.
Yes, Lordship.
Why can't you say that? And simply you are saying you want an adjournment.
Lordship, we haven't received the recent instruction, Lordship.
So say that. So you want up-to-date instructions for filing affidavit. How much time do you want? Because you will be getting a last chance.
1 week. 1 week.
Are you sure?
Yes.
It's going to be a last chance. After this, no more chances will be. If you are not filing your affidavit within a week's time, then on the next date of listing, the court is going to proceed with the averments made in the writ petition. Am I clear? Your name?
Alok Dev.
Mr. A. De.
Yes, Lordship.
D.V.
DEY.
Mr. De. Amit A. De. Heard Mr. A. De. Heard Mr. A.K. Sharma, learned counsel for the petitioner. Also heard Mr. A. De. learned standing counsel, GU.
Guwahati University.
Stop. Mr. A. De. learned standing counsel, GU, assures the submits that due to want of up-to-date instruction in the matter, another 1 week time is required for filing the affidavit in opposition in the matter. Stop. Prayer is not opposed. List this matter 2 weeks of list this matter on such and such date. Needless to clarify that if the affidavit in opposition is not filed by the next date of listing, the writ petition shall be taken up on its own merit.
In this case, my lord, we have already filed affidavit, my lord.
Yes.
This is infractuous, Lordship. In the meantime,
Infractious.
he received his pensionary benefit.
All right. Mr. Borwa, I don't think you need to say anything. Yes. All right. Give all your representations. Mr. Your name?
AMS Majumdar.
Mr. M.
AMS Majumdar.
AMS Majumdar, learned counsel for the petitioner, submits that the petitioner has received the
Pensionary benefit.
pensionary benefits claimed in the present writ petition, and accordingly he submits that the writ petition has become infractious. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, the writ petition stands dismissed for being infractious.
I am for responsible
Yes,
1,
yes. Give
4,
it,
and
give
6.
it, give it. Upart likhi dibo heart, everyone. Disposed. Di ase tumak namgur, huh?
Yeah.
May, my lord,
Kora.
on 11/9, my lord, 2023, my lord, the finance department, my lord, sought time for filing affidavit, my lord.
Finance. Yes, finance. Nayak. On 20.
11/9/2023. Last order, my lord.
Anyone from the finance department? After some time, get hold of someone.
Mal.
Mr. Mondal.
Mal.
Item 16.
May I please, Your Lordship? We have challenge and advertisement, my lord, at page number,
You have challenged
advertisement issued by the respondent number, at page number 11, Lordship.
advertisement by the Guwahati High Court,
Lordship, by the presiding officer, Labor Code, Lordship.
Labor Court.
Yes, Lordship. One post, Lordship, they have reserved for scheduled.
No
customers.
affidavits filed.
No affidavit. Lordship.
Your Lordship, in this matter, we don't require to, we may not file the affidavit in opposition. So your Lordship may kindly take up this matter on a hearing day.
Is that the common stand? Who's appearing for the Guwahati High Court? Mr.
Lordship?
H.K. Das?
Yes, sir. Your Lordship, I'm on behalf of HK Das.
MS
B. Saikia.
B. Saikia, learned counsel, on behalf of Mr. H.K. Das, learned standing counsel, GAC submits that they shall not be filing any affidavit in the matter and prays to take up the matter for hearing on any other date on any other date. Stop. List the matter on after 2 weeks on a date to be fixed by the registry. Needless to clarify that since the respondents have since the respondents have disclosed that they shall not be filing any counter affidavit in the matter, the writ petition shall be heard on its own merit.
Duly obliged, Your Lordship.
My lord, this matter pertains to compassionate appointment, my lord.
Affidavit, compassionate appointment.
Your Lordship, not required, Your Lordship, here because in terms of the Supreme Court judgment, recent Supreme Court judgment, the case of Devavata Tiwari, here the petitioner's father, he died in 2013.
2013.
13. So, 13, Your Lordship, that the whole...
And when did he make the application?
My lord, immediately after date, my lord, on 25th of March 2013.
Immediate.
Immediate.
Yes. Give me the date of application.
25th of March 2013.
25/3.
2013.
Yes. And date of death?
Date is 28th of February 2013.
Yes.
And DLC considered it, Your Lordship, may peruse to this...
DLC considered it when?
On 3/8/13.
3/8/13. Rejected by DLC.
Rejected.
No, my
No,
lord.
it was recommended.
Then what
SLC
happened?
recommended.
SLC rejected, Your Lordship.
The one that you are giving me is the SLC's rejection.
My lord, thereafter till 2018, the SLC has not considered the case of the petitioner. Accordingly, the petitioner approached the Honorable High Court, my lord. Honorable High Court directed the SLC to consider the case of the petitioner. Accordingly,
So
my lord.
SLC rejected it on 31/12/18.
Yes, Your Lordship.
On the ground that he could not be accommodated within the 5% quota meant for appointment on compassionate ground.
Yes, my lord.
This consideration was done as a one-time measure and the petitioner's candidature will not be considered again. Yes, there is a ground. Now, what is wrong in the SLC's rejection?
My lord, my contention is that, my lord, the SLC stated in the minutes of the meeting that not within 5% quota, my lord, but it has not been clearly stated, my lord.
What
The
more
5%,
to be stated?
that is, my lord, the 5% of if in the year 2013, then how the DLC has recommended, my lord. DLC has recommended, it means, my lord, it is within the 5% quota, my lord. But the
Yes, you are
SLC,
referring to some Supreme Court decision.
Yes, Your Lordship, I don't have a copy right now. Your
Why?
Lordship, Your Lordship may fix it on a hearing day on Tuesday, then I'll produce that. In fact, last week,
So I'm
Your
having
Lordship,
it, you try and we'll just keep it.
I have a copy in my...
Give it,
mobile
get a
itself,
print.
Your Lordship.
Wait for some time.
oblige, Your Lordship.
You keep print lage dीजिए. Yes, APDCL. Yes, Mr. Chaudhary.
Pleadings are
Affidavits
complete.
filed.
Yes, ma'am. Pleadings are complete.
Where is your other side? None appears for the petitioner when the matter is called. Stop. Mr. B. Chaudhary, learned counsel for APDCL, is present. List this matter after 2 weeks on a date to be fixed by the registry. Yes, daily wages, Mr. Bora.
Yes, look.
Affidavits not filed?
Not filed. Now, this matter has come up after my lords for the first time since 2022.
All right, we'll give them a chance.
My lords, I'll file the
How much
affidavit.
time do you need?
3 weeks, my lords.
3 weeks. As prayed for by Mr. B. Chaudhary, learned standing counsel APDCL, which is not opposed by the other side, list this matter after 2 weeks to enable the APDCL to file their return in the matter.
On the plate. On the plate.
List after 2 weeks on a date to be fixed by the registry.
On the plate.
Until 20 to 24.
Wait, please, Your Lordship. In these 5 matters, my lord, I had received instruction, my lord,
And these 5 petitioners, my lord, their requirement is, my lord, 39,39,570, my lord. And my lord, department
You are
is
for APDCL.
no, my lord, soil conservation department.
But even here, APDCL is there.
APCDC, my lord,
Huh?
Assam Plantation Crops Development Corporation.
APCDCL.
Assam Plantation Crops Development Corporation.
Yes, you need a fund of 32 lakhs.
My lord, 32 lakhs available, my lord. We are ready to give them, my lord, release them. And other 7 lakhs, my lord.
Yes. When the same is received for finance.
Yes, my lord.
Who is appearing for finance department?
My lord, till that they have not filed any affidavit, my lord.
But I think their presence would be essential, because now we are only concerned how much time the 7.43 can be released. Correct?
My lord, may I submit?
Yes.
On the last petition, Lordship may kindly peruse the last order, 2/8/2022.
Yes.
When they are going to pay. If that information is not furnished, then personal offense at 2 o'clock today. That was the order.
No, my lord, the instruction, my
No,
lord.
right now,
I have received instruction,
yes,
my lord.
you are MS Diori.
Yes, my lord.
Ms. Diori has given an instruction
No,
as
when
regards
they are
the
going to-
soil, where she has clearly indicated that 32 has already been disbursed, and as regards the 7.43 lakhs, the same as and when is received from finance can be disbursed. Now, how will Ms. Diori tell you a time frame? It is for the finance to say. You are for finance, Mr. Nayak? Yes. How much time do you need? Because we are only, the sport is only concerned about how much time you will take. Nothing more, nothing less.
This is a proposal, Lordship. It's not that they will submit one proposal and finance department.
I'm asking, therefore, I'm asking how much time you will take.
Lordship, let me
Otherwise, I'm disposing it of giving you a time frame of 2 months from the date of receiving this instruction. I think that should be sufficient.
For payment,
Why for payment, for consideration?
My submission will be legally they are not entitled to claim anything from the government. Lordship. It's a corporation. Several judgments are there. Our High Court judgment.
So you consider the soil conservation department has already cleared it. They are the department concerned.
No, they are the administrative department. But whether it will be approved, it is a proposal in the, type of supplementary.
How much
demand.
time do you need to put your affidavit?
Lordship will grant me 1 week time. In the meantime, I will take the instruction. What is the status of this proposal?
MS RS Deori, Learned Counsel for the respondent APC, no, for the your standing counsel.
Yes, my lord.
Standing counsel, Soil Conservation Department.
1, 3, 4, and 5.
Has produced a within bracket respondent 1,
3, 4, and 5.
3, 4, and 5. Has produced a communication dated 13/8/2024 received by her pursuant to the order of this court passed on 2/8/2024 to the effect that the MD APCDC has a fund of 32 lakhs which shall be disbursed amongst the 5 numbers of petitioner against the leave, salary, and gratuity of the aforesaid petitioners. Stop. She further submits that as regards the remaining amount of rupees 7.43 lakhs is concerned, the same shall be disbursed as and when, what is SD?
Supplementary demand.
Supplementary demand amount is received from the finance department. Stop. I don't think any exercise is required. They are already paying. This is only regarding the balance.
That was earlier granted by the government. Lordship.
Mr.
Now, this will be placed
P.
before
Nayak,
Assembly.
Learned Standing Counsel Finance, seeks 1 week time to obtain instruction as regards
the status of the supplementary demand proposal.
as regards the status of the supplementary demand amount proposal received from the Department of Soil Conservation. Stop. List this matter after 1 week. List on such and such date.
Well, in the meantime, the 32 lakh may be released enough.
Needless to clarify that in the meantime, the 32 lakhs as stated in the aforesaid communication shall be disbursed, shall be released to the petitioners and in accordance with law. Stop. the communication dated so and so is kept on file and marked as X.
Obligement.
Much obliged.
This is item numbers 22.
24.
Item 25.
None appears for the petitioner when the matter is called. List again after 2 weeks on a date to be fixed by the registry.
Well, I'm for respondent 1 to 3.
I put up 4, my lord.
All right.
Name me briefly.
Item 26.
Respondents are represented through their counsels.
Hello, sorry for this earlier item, Your Lordship. I'm in court number there, my lordship.
What's your name?
B. Bhuya, my lordship.
Your name to DDO. All right. Next. Yes. None appears to do. Yes.
May I please, Lordship, this matter pertains to selection and appointment to the post of Anganwadi worker.
Affidavits have been filed.
Affidavits have been filed. Readings are completed, Lordship. And
Readings are
Lordship,
completed.
my main ground would be also the respondent number 8, who is the chairman of the selection committee. He himself began an inquiry officer, and necessarily he would be biased against me. And there is a Supreme Court decision on that point, Lordship. My ground is
I'm sorry, you are challenging what in this
the
petition?
selection and appointment of respondent number 6.
Selection and
Appointment of respondent number 6.
R6.
Lordship.
Now, what
Lordship,
is the ground of bias?
because the advertisement says that one needs to be a permanent resident of the particular locality. But she was a tenant. She was not
She was
a
tenant.
She was a tenant in that area. She was not a permanent resident. Now, Lordship, there is an inquiry, and in the inquiry, Lordship, the respondent number 8, who was the chairman in the selection committee, he became the inquiry officer.
We'll admit it. We'll need some hearing,
Lordship.
right?
Otherwise, we have got the instructions also. We have got a.
What is your instruction? You've already filed your affidavit of
Yes,
election.
after filing of the affidavit, we were directed to inquire as to the residential status of the private respondent as vis-a-vis the petitioner. And after inquiry, we found that she is the private respondent is a resident of that particular area.
So she is the respondent number 6
6.
is a private respondent.
Yes.
But
And
why
also,
don't you put that by way of an affidavit? Because give them a chance.
Yes, very
Because this is this.
No, the inquiry report is already there.
After
inquiry
filing
report
the
is there, this instruction after this.
Mr. Counsel, if you do not want it, that is your choice.
Yes.
But you see, the government has come up with some additional information after they have filed their return. Now, to be fair, I am asking them to put it in by way of an affidavit. You want it or you don't want it?
Yes, I want it.
Inquiry.
Mr. D. Bora, learned standing counsel,
No, government advocate.
learned government advocate for the state respondent submits that pursuant to filing the affidavit in opposition in the matter, comma, an inquiry was conducted as regards the status of permanent residence of the respondent number 6
Vis-a-vis the petitioner.
vis-a-vis the petitioner, and he has received a communication
dated 10/5/22.
dated 10/5/22
itself.
2022, whereby a copy of the said inquiry.
Not copy, basically
Lordship,
communication.
Lordship, may I interfere? This inquiry report is already a part of the records.
It's already part of the record.
Record.
It's not a fact.
This is not a new thing. It is already part of the record.
All of this can be
heard so and so and so and so. This matter requires full-fledged hearing. Admit, no formal notice. List. List for hearing in the month of October. November.
Obliged.
Item 27.
November on any date to be fixed by the registry.
May I please, Your Lordship? The petitioner's case was not
affidavits.
The Lordship not required on the basis of the Devota Tiwari judgment. The Lordship can take up this matter as well as the item number 17.
17 counsel is here.
Yes.
We call this together. We'll take this up
After
along with
some time.
17.
Yes.
We'll get hold of the petitioner.
Yes.
Item 28.
Wait, please, Your Lordship.
Yes, family
My-
pension.
My lord. My lord,
No
the
affidavits.
SLP has already dismissed, my lord.
Lordship, dismissed but with liberty to file a review petition, Your Lordship. Lordship, we are preparing our review, Lordship. So, Lordship, kindly 3 weeks time may be given to our file.
As prayed for by MS.
J. Bora, Lordship.
J. Bora, Learned.
Lordship, Council, Lordship.
For.
PNRD Department.
Learned
Lordship.
Standing Counsel for PNRD Department.
Lordship, 1, 4, 6 and 7, Lordship.
6, how much time?
Lordship, 4 weeks time.
4 weeks time to file an additional, to take steps. To take steps in view of the development in view of the development before the apex court in SLP being diary number 24107/2024. Stop. Prayer is not opposed. List this matter after 2 weeks on a date to be fixed by the registry.
My lord, compassionate family pension, my lord, yes, yet to be released. My lord, that may be directed.
It's all right. That let her do, and on the next date.
Lordship.
2 weeks.
Highly obliged, Your
Lordship.
Lordship.
29.
Lordship, in this matter, we have not received our instruction, Your Lordship. Instruction is not received, Your Lordship. So, Lordship, kindly.
One affidavit already filed. That was filed by.
Filed by Lordship.
This affidavit is additional affidavit.
Additional affidavit.
Oh, additional.
Lordship.
Again, as prayed for by MS so and so, Learned Counsel for the PNRD Department.
Lordship, PNRD.
PNRD Department, respondent numbers 2, 3, 4, and 6.
Lordship.
Which is not opposed by the other side, comma, list this matter after 2 weeks to enable the PNRD Department to file their return in the matter.
I'm obliged.
Date may be fixed.
Registry will give it.
All right.
Time being items 17 and 37.
17. Yes.
Lordship, if your Lordship takes up the judgment, because the whole issue as such is the ground of delay, and more particularly paragraph number 7.5.
Paragraph number
7.5.
Yes.
So if I may just read out.
Please.
Considering the second question referred to above, in the first instance, regarding whether application for compassionate appointment could be considered after a delay of several years, we have the view that in a case where for reasons of prolonged delay, either on the part of the applicant in claiming compassionate appointment or the authorities in deciding such claim, the sense of immediacy is diluted and lost. Further, the financial circumstances of the family of the deceased may have changed for the better since the time of the death of the government employee. In such circumstances, courts or other relevant authorities are to be guided by the fact that such prolonged period of delay, the family of the deceased was able to sustain themselves, most probably by availing gainful employment from some other source, granting compassion.
One second. But you see, these are this paragraph is against in a situation where one files an application after a long time. Here they have filed an application immediately.
No, here in that case, this case also they have not
No,
filed.
it says considering the second question referred to above in the first instance regarding whether applications for compassionate appointment could be considered after a delay of several years.
It is with regards to consideration of that particular
Here in his case, it has already been considered and rejected.
Yes, it was rejected. It was rejected.
Yes,
Long time back in
and the
2018.
rejection is not for delay.
No.
Rejection is by giving some reasons. So how is this decision relevant?
Your Lordship, relevant to the sense, in the sense that the petitioner's father died in the year 2013. We are in 2024.
Mr. Counsel, you're not answering to the question posed by this court. In what context are you referring this decision? Because here the application was filed on the next month and DLC considered, SLC rejected.
And
not on grounds of delay.
Not on grounds of delay.
So why are you?
Now I'm placing the judgment because considerable period of time has elapsed.
No, that can't be.
Because the
that
whole
cannot,
move-
with utmost respect, that cannot be you cannot say that is the interpretation of the apex court decision. In that case, in all cases where there is the cases are pending before the High Court for consideration, and it comes after 5-6 years, the government will be taking that stand. How can that be?
Even then,
Where
so,
is the
Your
fault
Lordship.
of the
Even-
petitioner here?
Even then,
He
so,
has
Your
filed
Lordship.
it immediately.
Even then, so, Your
The
Lordship.
person expired on 28 February 2013, and on 25th March 2013 he had filed an application which the DLC considered on 3rd August 2013, and SLC rejected on 13/12/18.
18.
Thereafter he has filed a petition, and his petition is pending here.
Yes.
What can be done then?
Even then, Your Lordship, even then also, this particular his application
You may
was-
have a good case on merit otherwise, Mr. Counsel, but this is not a ground.
Very well.
You cannot take advantage of this delay and say
Very well.
nothing can be done.
Very
In that
well.
case, we'll have to list all the compassionate appointment and dismiss one by one. That is filed in the year 18, 19, 20.
Very well, Your Lordship. Even then also, here in the at page number 44, the SLC rejection order,
Yes.
not within the 5% quota.
Correct. You come to, that's why I'm saying you may have a good case on merit.
So his case was considered.
Where is the rejection?
Page number 44.
Relevant.
Serial number
relevant person is
25.
at 44. Serial number 25.
44.
44.
Serial number
25. Sri Chandra Kumar, Chandrakanta
and
Bodhi.
the other petitioner in the other case.
Lordship, my case is different. My case is covered by.
All right, then we'll come to you later.
Yes.
Where is that order we just read, that SLC's
Page 44.
page?
Page 44. And I just
No,
placed,
no, that quota thing. Where
Yes.
is it mentioned?
Yes,
I
you
just
have
placed
mentioned
that
my lord.
particular instruction, Your Lordship. I didn't get back that instruction somehow.
It simply says not within 5%
Not
quota.
5% quota.
That is my grievance, my lord.
Okay, this one.
Yes, Your Lordship.
Yes, how will this court go into it?
Yes, my lord. That is
And just
difficult, my
because
lord.
the DLC has recommended doesn't mean that then in every cases, how can you make that submission? There is no right that has accrued in your favor. The recommendation of DLC is given to you.
Yes, my lord. I have got a copy, my lord.
Where?
My lord, I have annexed it at relevant proportion is at page 21, my lord. It continues from page number 19.
21. No, where is it marked to you?
My lord, name mentioned, my lord.
Name, page?
Page number 21.
Yes.
Petitioner's name is on the top, my lord. Top table. That is Chandrakanta Bodole, third column, my lord.
Chandrakanta.
Yes,
That is
sir.
your name is mentioned. They are
Yes, sir.
recommended, but this has been served to you.
No, my lord, I have collected from the authority, my lord.
Correct. That's why I'm saying it has not been served. Therefore, no right has accrued to you. You cannot base your claim on because the DLC has recommended. It is only a recommendation. SLC, state level committee, has considered and rejected your case.
Yes, my grievance only against, my lord, that order
Yes,
is
what
not
do you have to say
reasoned,
against
my lord.
this, Mr. Bora?
Your Lordship, even if I go by page number 21, that 5% post is not of the one particular, it has to be of the total vacancy. Say suppose there has to be minimum 20 number of posts vacant. Out of that, 5%, that is one post is earmarked for, out of those 20 posts is earmarked for.
You have not
compassion.
filed your affidavit in
No,
this
Your
matter.
Lordship.
Why don't you clarify this?
Then, Your Lordship, I'll file an
You
affidavit.
file an affidavit and clarify it.
Yes. Very well.
Only that much my complaint, what he is submitting.
Just to this
On
point.
the basis of the OM, because the OM says that.
Very well, because you see, I may be wrong, but I don't think there is otherwise any merit in this repetition. Because
Yes,
so you clarify that stand. If he wants to file a reply, he'll file it, and then finally the court can dispose of this repetition.
Very.
I will say that you will file your affidavit, and you can give me a date, and then we can say at the administration stage itself, then an endeavor can be made.
Very
Right?
well, Your Lordship.
Mr. D. Bora, item 17. Item 17, Mr. D. Bora, learned standing counsel or government advocate?
Government advocate.
Learned government advocate for the state respondent, seeks 2 weeks time to file affidavit in opposition in the matter to clarify the stand of the state government in the matter. Stop. Prayer is not opposed. List this matter after 2 weeks on a date to be fixed by the registry. Stop. Needless to clarify that upon the affidavit in opposition being filed, an endeavor shall be made to dispose of the writ petition at the admission stage itself. 17. Now next.
27.
Yes. What in 27?
Lordship, my case is covered by two judgments of this Honorable High Court.
Yes. Who died?
Husband of the petitioner.
When?
2013.
Date.
16/9/2013.
16/9/2013. Application when?
Lordship, application date is not here, Lordship, but kindly see page 19. While proposal was sent, there is written that within time, Lordship.
This is the proposal.
Proposal from the DLC, Lordship.
This is in the year 16.
Yes, Lordship, kindly see now, Lordship, page.
But when did you make the application? That's a relevant date.
Lordship, that date is not.
When?
Lordship, kindly see that.
The date will be very important, isn't it, Mr. Bora?
Yes, Lordship.
Have you filed your return?
I don't have instructions to
Please
that.
get your instructions.
Lordship, kindly see, Lordship.
Mr. Counsel,
Lordship.
I will not see the order today because you do not even know on which date the petitioner has filed the application
Yes,
for
Your
compassionate appointment. You are only showing an order of 2016, which is after 3 years of the date.
Lordship, there.
As prayed for by Mr. D. Bora, Learned Counsel, Learned Government Advocate for the state respondent, list this matter after 2 weeks to enable the state government to file the return in the matter.
Lordship, can a date be fixed, Lordship?
All right, next.
Oblige.
May I please, Your Lordship? Lordship, I am for the private respondents number 6, 7, and 8. Lordship, we have filed our affidavit in opposition today, Your Lordship.
You filed today?
Yes, Your Lordship.
This is item number
55, Your Lordship.
Supplementary.
We have served the copy also.
None appears for the petitioner when the matter is called. Stop. Mr.
A. Khan.
Mr. A. Khan, Learned Counsel, appearing on behalf of?
My name is David Item respondent number 6, 7, and 8.
Respondent number 6, 7, and 8 submits that an affidavit in opposition has been filed in the matter today. However, the same is not on record. Let registry verify and place the same on record. That none appears, Kusla. Yes,
Yes, my lord, I'm here.
MS?
MD Medhi.
MD Medhi, Learned Counsel.
Today I received the copy of this.
List after 2 weeks. You want to file a reply?
No need to reply.
List
For
next
hearing,
week? Next week or
Next
after
week.
1 week?
27 it may be fixed, my lord.
Okay,
Other
list
cases
on
fixed. Highly obligeous.
Obliged, Your Lordship.
Please, Your Lordship, my lord, today I'll file the affidavit for newspaper publication, my lord. One
item 30.
My lord, I'll file
235 days delay.
Yes.
Yes.
There's newspaper publication, my lord. I'll file affidavit today, my lord.
For
newspaper publication.
service response affidavit.
For service of notice upon the respondents.
Your name?
VK Borwa, my lord.
Mr. VK Borwa, Learned Counsel for the applicant appellant, submits that he has taken
newspaper publication
steps for service upon respondent number
1, 2, and 7.
1, 2, and 7 by newspaper publication. Stop. He accordingly seeks 1 week time to bring the same by way of an affidavit of service. Prayer allowed. List this matter after 1 week on a date to be fixed by the registry.
Highly obliged.
31.
Yes, Mr. Vatra.
My lord, the appeal was admitted, my lord.
Yes.
After we took steps, but my lord, the office note says
R2, R3 could not be served as addressee could not be traced out. Yes.
And my lord, in the condonation application also, we had to ultimately take steps by Dusty. So what I, my lord,
You
submit.
do the needful and then file an affidavit of service?
My lord, we would like to take steps by paper publication, my lord. Because they are trying to avoid service. Policy is in question.
No, but it says I like the service report.
My lord.
I would like to inform that notice issued to so and so is duly served upon him in the mentioned entries. This is who?
Respondent 1, my lord.
Taslima.
My lord.
It's served, it says. One is served.
One is served. One is the claimant respondent. Yes.
2 and 3.
2 and 3, the owner and driver.
It says after inquiry, the respondent is not known by the people of that locality.
Yes, ma'am.
To substantiate, process server took signature of villager of that locality. No, but if suppose he doesn't stay there, then
Well, the policy was issued on the same address. He was the owner of the track. He's trying to avoid the service
no,
because
but he is
the
not
policy-
known in that locality.
Well, for obtaining a policy, he must have given the copy of RC and all other relevant documents before the insurance company. He's the owner of a truck. He cannot elope.
Shall we try once more fresh?
As your lordship, please.
Let's try once.
Because Dusty is not going to work in the
No,
condonation.
let's do it like this.
My lord.
We will allow you, Dusty.
My lord.
If you fail, you put an affidavit. On the basis of your affidavit, it would be easier for the alternative modes of service.
My lord.
Right, Mr.
As your
Vatra?
lordship.
I think it would expedite then.
My lord.
Because
My lord.
that report says nobody knows him in that locality.
Yes, ma'am.
So,
As because there was no policy to the truck, they are
so
trying
you
to avoid.
indicate that
My
as
lord.
per the address disclosed in the policy
Yes,
and in that
yes,
whatever,
Yes, ma'am.
you have attempted
My lord.
whether if he was there and he was not accepting, then you say that. And if he's not available, say that, then alternative, whatever can be done, isn't it?
As your lordship.
Mr. A. Vatra, Learned,
RK.
I'm sorry, R.K. Vatra, Learned Counsel for the petitioner seeks 1 week, 2 weeks?
2 weeks, ma'am.
2 weeks time to take fresh steps of service upon respondent number 2 and 3, both by registered post AD as well as by Dusty. Prayer is allowed. List this matter after 3 weeks.
3 weeks, ma'am.
After 3 weeks on a date to be fixed by the registry.
Obliged.
32.
Take it.
Wait, please, your lordship.
Yes.
My lord, as per office note dated 15/7/24, lordship, notice of respondent number 1 and 2 return, lordship, due to insufficient postal send. I may be allowed 1 week
All
time,
right.
lordship.
MS
M. Choudhury.
MS M. Chaudhary, Learned Counsel for the petitioner seeks 2 weeks time, 1 week
I
time.
am for the appellant, lordship.
Appellant.
One
For the
week time,
appellant
lordship.
seeks 1
1
week,
week time.
1 week time to take fresh steps upon respondent number.
Lordship, 1 and 2 to clear the defect, lordship. Here it is returned due to the insufficient postal stamp, lordship.
Which is the respondent
1, 2, and 3. 3 already appeared, lordship.
for 1 and 2.
1 and 2.
On behalf for 1 and 2, prayer allowed. List after such and such date.
1 week time may be allowed, lordship. Must oblige, lordship.
33.
Yes, service complete. R9,
Yes, Lordship.
8 and 9,
Yes, Lordship.
all. Everybody is represented?
Yes, lordship, I'm appearing for respondent number 8.
Yes.
Petition DNS.
You're for 8 and 9? Yes.
My lord, so far respondent number 6 is concerned.
Yes.
My lord, your lordship will find this United Bank of India is a defunct body. So therefore, my lord, they are required to file an appropriate application to implement Punjab National Bank.
Punjab National Bank is not there.
Not there.
Yes. Are you going to take steps?
Lordship.
Then we will just simply give you 2 weeks time to do the needful. We are not recording anything.
Lordship.
Mr.
D. Dole, Lordship.
Mr. D. Doloy, Learned Counsel for the petitioner, seeks 2 weeks time to bring Punjab National Bank as an arrayed respondent by filing necessary application. Prayer allowed. List after 2 weeks on a date to be fixed by the registry.
Obliged.
I shall just resume in 5 minutes.
Lordship, in this case,
21 days delay.
Yes, Lordship. Service is
completed.
So we have explained the delay in paragraph
1
3.
second. None appears for the other side.
Actually, for 5 and 6, someone is appearing, but for 1, 2, 3, 4, none has appeared. Those service is complete.
5 and 6 name is shown. Okay.
Names are shown. Lordship.
All right. And for 2 and 3,
1, 2, 3, 4, service is complete, but none has appeared for them. Lordship.
AD cards have been received back. All right. Yes. Grounds of delay.
Lordship, I have mentioned in from paragraph 3, Lordship. Actually, the judgment was passed on 4/11/2022, and legal opinion of the dealing council was received on 1/12/2022 after 27 days. Main delay is on that only, Lordship, and thereafter certified copy was applied. That is what I have mentioned at paragraph 4, and then the official delay, Lordship, like it was put up.
All right. Kalpana, item 34. Heard MS RD Majumdar, Learned Counsel for the applicant. Stop. Also heard.
None appears.
None appears for the respondents, though the office note indicates service completed against respondent numbers 1, 2, 3, and 4. Stop. Further, though the name of the counsel appearing for respondent numbers 5 and 6 is reflected in the cause list, none appears when the matter is called. Accordingly, the instant application is taken up for hearing. The instant application is filed under section 173 of the MV Act, read with section 5 of the Indian Limitation Act, seeking condonation of delay of 21 days in filing the appeal against the judgment passed on 4/11/2022 by the learned member Moto Excellent Clients Tribunal Kachar Silsar in Amesi case number 81 of 2013. Stop. MSRD Majumdar, Learned Counsel for the petitioner, submits that the delay occurred for reasons beyond the control of the petitioner, and specifically because of the time taken by the divisional office in furnishing the legal opinion sought after the passing of the judgment dated 4/11/2022. Stop. I have given my prudent consideration to the arguments made by MS so-and-so and to the grounds averred in the condonation application. Stop. Paragraph 5, 6, 7.
No, 3, 4, 5. 3, 4, 5, 6.
Paragraph 3, 4, 5, 6 is reproduced here under for ready reference of the condonation application, of the interlocutory application. Page 4 আৰু 5 পাবা. Apparent that due to non-receipt of the legal opinion, due to delay in receiving the legal opinion as sought for in the matter, comma, the delay of 21 days occurred. I'm of the opinion that the aforesaid delay, that the aforesaid explanation given in the interlocutory application is sufficient and bona fide. As such, the delay of 21 days stands condoned. I disposed of, let registry register the accompanying MAC appeal.
Highly obliged, Lordship.
35.
In 35, Lordship will peruse office note
42
dated-
days.
Lordship?
42 days.
Yes, Your Lordship. No. 42 days. Sorry, yes, 42 days. But Lordship.
Service not complete.
Yes, Lordship. 4, you are for 4. 4 has filed wakalatnama. For 1, 2, 3, nothing has come as yet.
So
Lordship.
we'll have to
we have to wait.
Await service is in respect of respondent numbers 1, 2, and 3.
Lordship, I am for respondent number 4, F and Jaman.
MSF Jaman ওপৰতে লাগিলে দি দিব regular for the applicant আৰু F Jaman
F and
and
Jaman.
appearance for R4.
Highly obliged.
Obliged.
2 weeks. 2 weeks. List after 2 weeks on a date to be fixed by the registrar.
36.
Service completed.
May I please, Your Lordship? Lordship, I am for respondent number 1, Lordship, and as per instruction of my senior Lordship, I need further 2 weeks, Lordship, for filing written objection.
I am also
225 days delay.
Yes, Lordship.
My lord, I am also insurance, my lord, for the insurance respondent number 4.
You
my
also
lord.
want to file
Yes, my
objection?
lord. Yes, my lord.
So all the respondents are otherwise completed?
Yes, Lordship.
What about one? You are for?
I am for 1, Lordship.
1. And you are for?
4.
Insurance.
What about 2 and 3?
Not complete, my lord.
Is completed. Heard Mr. A.R. Agarwal, Learned Counsel for the applicant. Stop. Also heard Mr.
A.R. does?
A.R. does for respondent number
1, Lordship.
1 and MS
L. Sharma.
L. Sharma for respondent number 4. Office note dated 5/3/24 indicates that service in respect of the respondent numbers 2 and 4 stands completed.
Then funding 1 and 4. 1 and
No, service in respect of the other respondents, i.e. 2 and 3.
Lordship, I am for respondent 1, Lordship.
2 and 3 stands completed. Okay, I got to me kak dila 1 and 4. Na?
1 and 4.
Respondent? No, 1 and 4. 1 and 4. 2 and 3 completed. Mr. So-and-so and MS so-and-so appearing for the respondent seeks 2 weeks time to file their objection in the matter. Prayer is not opposed. List this matter after 2 weeks on a date to be fixed by the registry.
37.
Yes, affidavit.
My lord, this is regarding non-term of my lord pensionary benefits since 27/6/2018.
23 matter affidavit.
My lord, I'm praying for 2 weeks more time. My lord.
As prayed for by Mr.
K. Vishwakarma,
K. Vishwakarma, Learned Counsel for the
Union of India, on behalf of Mr. SP Chaudhary.
Mr. Respondent numbers.
All the respondents, my lord.
For the respondents, list this matter
After 2 weeks.
after 2 weeks on a date to be fixed by the registry to enable the union government to file their return in the matter.
My lord, last August and also my lord 2 times.
All right, let it be
I
filed.
oblige.
It's a 23 matter,
Yes, my lord.
but it's a pension, relating
Yes.
pension. So, needless to clarify that since the matter pertains to non-payment of pension, comma, it is expected that the respondent shall file their necessary return by the next date of listing.
Yes. Obliged.
I oblige. my lord.
501 days of delay. Yes, all respondents.
Respondent number. Can you praying for respondent number 1, my lord?
You have filed an objection.
Yes, my lord. We file an objection.
But your objection, yes, it is there. Yes,
Yes, Lordship, I humbly play that this is.
I cannot hear you.
Like Clement's appeal, Lordship, for enhancement only, Lordship. And the thing is.
No, but today we are taking up the interlocutory application for condonation.
Yes, Lordship.
Yes. 501 days.
1 day, Lordship.
Yes, what is your explanation for that?
Explanation is.
First, show me sufficient cause
Yes, Lordship.
before you take me to the merit of the case.
Yes, Lordship. The para number 3, 4, and 5, Lordship. I've stated the condonation prayer, Lordship, delay, why it is occurred, Lordship. And again, Lordship, this for Clement's appeal, Lordship, for enhancement of compensation, Lordship. And in this regard, Lordship, Honorable Supreme Court as well as High Court has condoned.
Mr. Counsel, before you take me to any decision of the top court or of this court, first you show me what is your explanation.
Explanation, Lordship.
You have not even bothered to read. You want the court to read?
Yes, Lordship.
Please read paragraph 3.
Paragraph 3, the judgment and award was passed on 6/7/21, Lordship. The lower court counsel applied for the certified copy of the same on 23/2/22, Lordship. The said certified copy was ready for delivery on 25/2/22 and was delivered on 25/2/22. But the lower court counsel informed of passing of the judgment only on 15/3/22, Lordship. And the
Why did you take so much time in applying? The judgment is of 6/7/21 and it says you have applied on 23/2/2022.
Yes, Lordship.
Exactly.
Exactly.
What were you doing from 6/7/21 to 23/2/232?
I don't know about the passing of the judgment.
Where have you said that?
That the lower court counsel informed Lordship me on 25/2/22, Lordship. And immediately I went and judgment only on 15/3/22, Lordship.
Mr. Counsel, I'm sorry, but the dates do not tell you. You see, but the lower court counsel informed the passing of the judgment only on 15/3/22.
Lordship.
And you have said that you have applied for the certified copy on 23/2/2022 before this date.
Lordship, lower court counsel has informed me he has applied for the certified copy and he informed me passing of the judgment on 15/3, Lordship, 22. He has already applied.
I have not understood this explanation.
My lord, from the date of the judgment till the date of filing this condonation petition, it is 829 days, not 501. If we condone the 90 days, then it comes to 739 days. The petitioner has misled this honorable court, my lord.
But how did the registry do the calculations?
On record, my lord, only the certified copy dated 11/10/23 has been shown. I am stating on the para number 3 that has been filed by the applicant, my lord.
There is one certified copy of 23/2/22. Correct?
Yes, my lord.
23/2/2022.
23/2/2022.
And for the on so and so was made ready for delivery on 25/2/22.
It took, my lord, 232 days for applying the certified copy, my lord. Then thereafter, it took another 195 days to receive the photocopy of the judgment.
And where is that explanation as regards that initial, that explanation?
No explanation, my
Lordship, then I could not get this evidence copy, Lordship. Judgment copy was received, but a copy of evidences, those were vital for filing of the appeal, Lordship. And again, this is summer vacation holidays and other holidays, and due to
my lord, those explanations are absurd, my lord. If my lord go through my objection, my lord, at page 12, I have given the detailed chronology of how the explanation they have been making from the judgment and order passed on 6/7/2021. They apply certified copy after 232 days, that is on 23/2/2022.
See, Mr. Counsel, all these explanation in paragraph 3 appears to be after 25/2/2022.
Yes, Lordship.
What were you doing from 6/7/21 to 25/2/2022? Where is that explanation?
No, Lordship.
How much did this first part? 200?
My lord, 232 days.
232. What were you doing for this 232
Lordship,
days?
I don't know about the passing of the judgment, Lordship.
That again you are saying, but the lower court council informed the passing of the judgment only on 15/3/2022.
Lordship.
What actions have you taken against this lower court council?
Lordship, because I went there and because of a rustic villager, etc. Lordship.
No, but what have you done? Because it's a very vague, you can't simply blame it on a lawyer. Very vague. Yes, sometimes it happens.
Yes, Lordship.
The litigants are not expected to act like a watchdog. There can be some delay because once you have engaged a council, you might, it is for the council to notify you of the developments.
Yes, Lordship.
But that doesn't mean that you will be also sitting silently.
No, Lordship,
And if the lower court council have informed about the judgment after so many days, about 232 days, what did you do? You have not even named the council, number one. Number two, have you taken any steps against the council?
Lordship, I am being a lady, Lordship. Again, sometimes I could not contact Lordship because rustic villager lady, I don't know about the...
Where have you said all that? Where are those explanations?
Pair number 3 itself, Lordship.
No, paragraph 3 after this is post 15th March.
Yes, Lordship.
Pre 15th March. Where are those explanations?
Because of the council, Lordship.
Council, I understand that. Please try and understand what the court is asking. You are not required to explain every day, but 232 days that you have to give some plausible explanation. Simply saying the lawyer did not inform will not do. Now in court you are saying that the lady is illiterate, she is from the rural village.
Yes.
Where are those averments that she did not know? Where have you said all that?
Lordship, para number 7 it is mentioned, Lordship.
This is a general.
Yes, Lordship. And this is for claimants for enhancement or appeal only, Lordship. So humbly submit, Lordship.
Where is the objection?
My lord, we have filed the objection. My lord, page 12 at para 2, we have summarized what the applicant has stated.
These are the, you have just
brought for your lordship the facts.
And you have just put them by numbers, sequence.
Yes. Yes, my lord. Because the explanation has to be...
So this calculation, this the office has given, we will go by that.
My lord, but if we go through the judgment dated, then it comes to 829 days. And after reducing the 90 days period, it's come to 739 days. But how come it's become 501?
Judgment is what dated? 6/7/21.
6/7/21.
And it was filed on 13/10.
13/10.
Yes, I think then a report is to be called from the registry.
Yes, ma'am.
Mr. Counsel, let me call for a report because it appears that the judgment was delivered on 6/7/21. If you calculate till the date of filing, that is 13/10/2023, and the 90 days period is reduced, then it is 739 days.
No, Lordship, this is 6/7/21 judgment was passed, but Honorable Supreme Court has given this limitation extension period, Lordship, up to 28/2/2022.
That is that COVID period.
Yes.
That was that COVID period.
Yes, sir. It is there, Lordship. The COVID period up to 28/2/22, Lordship.
Okay.
So that may kindly exempted, Lordship.
Yes, anything more? No, because I am allowing it. Heard Mr. A.R. Agarwala,
yes,
Learned Counsel for the applicant stroke appellant. Stop. Also heard Mr.
C. Fukan, my lord.
C. Fukan, Learned Counsel, appearing for respondent number 1. Anyone else?
Nobody.
Stop. This is an application
That is complete for 2 and
under Section 5 of the Limitation Act 1963 for condonation of delay of 501 days in preferring the accompanying MAC appeal against the impugned judgment and order dated 6/7/2021 passed by the learned member Motor Accident Claims Tribunal number 1 Kamrup M Guwahati in MAC case number 1848 of 2017. It appears the appellant being aggrieved and dissatisfied with the aforesaid judgment and award dated 6/7/2021 passed by the learned member Motor Accident Claims Tribunal number 1 Kamrup has preferred the accompanying appeal before this honorable court. However, due to unavoidable circumstances, the said appeal could not be filed within the stipulated period of limitation. Stop. Situated thus, the present petition is being filed for condonation of the delay of 501 days in filing the accompanying MAC appeal. Stop. Mr. Agarwala submits that the delay occurred is unintentional and beyond the control of the appellant
claimant,
and therefore the same ought to be condoned. Stop. Mr. C. Fukan.
Yes, my lord.
Mr. C. Fukan, Learned Counsel for the respondent number 1, on the other hand, submits that the petitioner has not, that the applicant stroke appellant has not sufficiently explained the delay of 501 days and therefore the delay ought not to be condoned. Stop. I have next para. I have given my prudent considerations to the arguments made by both the parties and to the materials available on record, including the explanation given in the interlocutory application for condonation of the said delay. Stop. Paragraph 3. And 7 of the interlocutory application is reproduced here under for ready reference. Page 3 to page 6. Apparent that since the petitioner is an illiterate rustic villager, he or she could not keep a track with the engaged counsel, and after the passing of the judgment on 6/7/2023, comma, the engaged counsel informed her about the same only on 15/3/2022, comma, whereafter the certified copy of the said judgment and award was obtained, and after preparing, comma, the appeal was filed. However, in the meantime, the said delay of 501 days occurred. Stop. The aforesaid explanation appears to be sufficient and bona fide, and as such, I am inclined to condone the delay. Ordered accordingly, delay of so and so days condoned, disposed of. Let registry register the accompanying MAC appeal.
Next for admission.
39. Yes. 118 days. Service completed?
Service completed, Lordship.
Service completed for respondent number 1, 2, and 3. Respondent number 4 and 5 service not completed yet.
No, deemed complete. It as per order dated 27/5/24, Lordship will peruse. Already deemed complete 4 and 5.
Office
Not,
note or
no order, Lordship.
Which order?
27/5/24.
4 and 5 is deemed to be complete.
Yes, Lordship.
So all
service is-
completed. Now, who are represented? You are for?
Respondent number 1, and also we are representing 2 and 3.
1, 2, and 3.
Yes.
Are you appearing?
Yes, Lordship. No,
So only
Lordship.
only 4 and 5 is not here.
Lordship, I am appearing on behalf of engaged counsel P. Bordolo.
Yes, Ms. Majumdar, where is the explanation paragraph?
Explanation paragraph 3, 4, 5, Lordship. The judgment was passed on 30/11/22.
1 second. 3, 4, 5.
Yes, Lordship.
Legal opinion.
Yes.
191 days they have taken.
Yes. And thereafter there was no delay because it was put up on 36/23, and
So basically, the legal opinion, it took about 191 days,
Yes,
and
yes,
after that it was filed.
Yes, that's the explanation.
I am condoning it now, but then the legal opinion.
Usually, Lordship, insurance cases, most of the cases we file delay.
Lordship, we are seeking 1 week time to file objection.
What objection?
Sir,
There's only 118 days delay.
Sir, respondent could not come to sign the affidavit.
So, but what objection do you want to file? I could have disposed this of. Condone the delay.
I am not in this case. People learned.
Your name?
N. Buragohai.
As prayed for by MS?
N. Buragohai.
And Buragohai, learned counsel for the respondent numbers 1, 2, and 3, comma, list this matter after
1 week.
After 1 week to enable the said respondent to file their objection in the matter.
Highly obliged.
Pending item 15.
Finance at that time was not there.
Yes,
right?
finance.
Yes, Mr. Bhattacharya.
11/9. We have a set of instructions, my lord, that is, my lord, furnished by the Deputy Commissioner. Now, since I am not representing Deputy Commissioner, I have handed over it to my learned colleague. Here, my lord, the petitioner is working in the establishment of the Deputy Commissioner. And under the Treasury Establishment Rules of 1993, which is the admitted position here, my lord, the controlling and regulatory authority is the Deputy Commissioner. So let the Deputy Commissioner file an affidavit. That will suffice, my lord.
All right. In item number 15, correct?
15, my lord.
Mr. Your name?
A. Chakraborty.
I'll simply say you are seeking time.
Lordship.
Mr. A. Chakrabarti, learned government advocate,
Lordship.
for the state respondent, seeks 2 weeks' time to file the affidavit in opposition on behalf of the jurisdictional district commissioner.
Yes.
Stop.
My lord, here it will be, my lord, the respondent number 6.
Within bracket R6. Prayer is allowed. List this matter after after 2 weeks. After 3 weeks on a date to be fixed by the registry.
I am obliged.
40.
Yes, Mr. Batra, 28 days. Service completed.
My junior colleague would like to place the case.
Yes, yes. Why not? Service completed or not?
No, your lordship, as per the office note dated 17/7/2024, the lordship R3 notice has been personally received and signed. And for R4, the brother of R4, who is R3, he has received the notice. R4.
R4.
Respondent number 4.
For respondent number 4, the respondent was not at home and the notice was instead signed and received by the brother.
Who is respondent number 3?
Respondent numbers 3 and 4 I represent.
So you are appearing. So 3 and 4 is done.
Yes, your lordship.
Then 1 and 2.
Incomplete address, your lordship.
Incomplete address. Then you take fresh steps. Heard MS A. Biani, learned counsel for the applicant. Stop. Also heard Mr.
A. Khan.
A. Khan, learned counsel for respondent number 3 and 4. Stop. Office note dated 17/7/2024 indicates that unserved notices in respect of respondent numbers 1 and 2 have arrived with the postal remark, with the common postal remark within quotes, incomplete address. Stop. Let fresh steps by the applicant be taken in respect of the respondent numbers 1 and 2 by furnishing complete address. List after 2 weeks on a date to be fixed by the registry.
Obliged, Your Lordship.
Your lordship, but the address for R1 and R2, it's the same.
It says incomplete address, so you verify. If there is anything, you put an affidavit.
Okay.
Obliged.
41.
None appears for the petition applicant. This is IN, okay? Our petition to some. None appears for the applicant when the matter is called up. It appears that on the last occasion, i.e. 21/12/2023, when the matter was listed, there was also no representation on behalf of the petitioner. Stop. In view of the consecutive non-appearance on behalf of the petitioner, তুমি হেৰিত লিখিবা হা ৰিট পিটিশ্যনটোত দিবা কি বুলি লিখিছিলা নহয় একদম ওপৰত কি লিখিছিলা call for then 1 second. Your name?
M. Das.
Ms. M. Das, learned counsel appearing for the PWD is present. Stop. It appears from the accompanying interlocutory application IAIA within bracket civil number 3741 of 2023 that when the said application along with the writ petition was last listed before this court, i.e. 21/12/2023, on that day also there was no representation on behalf of the petitioner. Stop. Next, in view of the consecutive non-appearance of the learned counsel for the petitioner, the instant writ petition along with the interlocutory application stand dismissed for non-prosecution. 41 na disposed of.
42.
Dutai disposed of. Yes, 101 days.
Yes, Your Lordship. Your Lordship, I'm representing on behalf of my senior, Anjana Gohai Chaudhary. Your Lordship, I'm from the appellant side. Your Lordship, as per...
Unserved notice.
Yes, Your
So
Lordship.
you take fresh steps?
Yes, Your Lordship.
Only R4.
R2 and 4.
R2 also unserved, but no, R2, no AD card, no unserved.
Yes, Your Lordship.
So you take again.
Yes, Your
As
Lordship.
prayed for by MS,
Reshma Khatun.
MS R Khatun, comma, no, as prayed Nukoba. You are appearing for
Respondent number 1.
MS so and so appears is present for the applicant as well as MS so and so for learned counsel appearing for respondent number
1.
1. Office note dated 18/7/2024 indicates that the respondent number 2 could not be tracked out as the address appears to be incorrect and therefore notice could not be served. Stop. As regards respondent number 4, it appears that the notice has been personally received and signed by the respondent. Stop. As regards respondent number 4, the respondent was not found at his address and the notice couldn't be served. No, as regards respondent number 4, unserved notice has arrived with the postal note within quotes insufficient address. Stop. In view of the aforesaid office note, service as respect of respondent number 3 stands completed. Stop. However, as regards respondent number 2 and 4, let fresh steps be taken by the applicant by giving the full complete address. List after 2 weeks on a date to be fixed by the registry.
I will oblige, Your Lordship.
43.
Yes, Mr. Talukdar, what is this?
An
Quite
affidavit
a
has been
voluminous
filed.
pleadings.
An affidavit has been filed last week by respondent
You want to
number 2.
file reply?
Just a week's time to file.
As
reply.
prayed for by Mr. K. Talukdar, list this matter after 2 weeks on a date to be fixed by the registry to enable the petitioner to file rejoinder to the affidavit, to the counter affidavit filed by
It's not
the
a counter affidavit, Malan. It's a preliminary affidavit. We have raised 2 issues.
to the preliminary objection filed by the respondent number
ONGC.
by the respondent ONGC.
I'm good.
Malan, I'm representing ONGC. Not
Didibo. Mr. K. Talukdar for the petitioner and Mr. S. Chakraborty for the
respondent ONGC.
For the respondent ONGC. You are standing counsel?
I'm the panel counsel.
44.
May I please, Your Honor?
Yes.
Your Honor, the engaged counsel's mother expired. It is back. Engaged counsel's mother has expired. It is back. So,
all right, but it seems the service has been completed.
yes, Your Honor.
It's deemed to be completed. This is a delay application.
Yes, Your Honor.
The P1 number? 186 days delay.
Yes, Your Honor.
Where is the ground? Have you read?
Your Honor, I don't have the brief with me.
Why you don't have the brief?
Your Honor, actually, the file is with the senior counsel.
Once again, I'm trying to help you here. It is 186 days. If I can condone the delay, do you still want an adjournment?
No, Your Honor.
That is why I want to see the explanation because service is completed. Second copy to deduction. 9 again. Yes, your name?
A. Rahman.
Heard, Mr.
A. Rahman.
A. Rahman, learned counsel for the applicant stroke claimants. None appears for the respondents despite the notice having been, despite service of notice having been completed. Stop. This is an application under Section 5 of the Limitation Act, read with Section 173 within bracket 1 of the MV Act 1988 for condoning delay of 186 days in filing the accompanying MAC appeal before this Honorable Court against the judgment dated 26/5/2023 passed in MAC case number 38 of 2020, passed by the member Motor Accident Claims Tribunal, Tinsukia. Stop. Mr. Your name?
A. Rahman.
Mr. A. Rahman, learned counsel for the applicant stroke claimant, submits that due to the unfortunate due to medical reasons of the applicant's minor daughter, comma, and being occupied with the consequent treatment, comma, the delay of 186 days occurred in filing the accompanying MAC appeal. Stop. I have given my prudent considerations to the arguments made by the learned counsel for the petitioner and peruse the materials available on record, including the explanation averred in the interlocutory application for condonation of the said delay. Stop. Paragraph 2, 3, 4, 5, and 6, 7, and 7, and 7 are reproduced hereunder for ready reference. Page number 4 to 6. Apparent that it is due to the medical emergency that has arisen, comma, the accompanying appeal could not be filed within the stipulated time. Stop. The explanation appears to be sufficient and bona fide for condoning the said delay of 186 days. Stop. Accordingly, the aforesaid delay of so and so is condoned. Hey, baki ki same, huh?
Much of it.
45.
Yes, service.
This is condonation of delay over 87 days only, Lordship, and the office note at 16/7/24, Lordship. Respondent number 1, anti-reference insurance company.
What about 3?
Lordship,
Await service.
Staff of Lordship.
Huh?
Those are not necessary actually for condonation delay.
No, but then they are await respondents.
Service
So
report is awaited.
await service.
No, Lordship, there is mechanically staff of.
Sorry? No, you have arrayed them. How can I strike them?
No,
Like the, have you made any application for striking their names?
No, Lordship, this is condonation delay.
It appears, please do not unnecessarily waste the time, judicial time of this court. As per office note dated 16/7/2024, it appears that service in respect of respondent number 3 and 4.
And Lordship, I am for respondent number 1.
2, 3, and 4 is still awaiting.
No,
Stop.
Lordship. 2 addressee not known, Lordship, as per office note.
So it's still okay. Sorry. It appears that service in respect of respondent number 3 is still awaiting. Stop.
Lordship.
Further, it appears that in respect of respondent number 2, the unserved notice has come back with the remark within quotes addressee not known, return to sender insufficient address. And in respect of our respondent number 4, within quotes addressee not found. So here upar jit koisa unserviced notices of respondent numbers 2 and 4 have come back. Ekelege di disu etu office note page 1 ot ase. Yes, are you taking fresh steps?
We'll take by
Mr. So and so
court process.
seeks how much time? 2 weeks time to take fresh steps in respect of respondent numbers 2 and 4 by furnishing proper address.
I am for 1, Lordship.
And
Lordship,
report
respondent number
so and so
3
address for 120. List after 2 weeks on a date to be fixed by the registry.
Must oblige, Lordship.
46.
Herein, Your Lordship, I am
For some correction.
Yes, correction for
respondents are appearing. Notice have not been issued.
Notice has not been issued here.
Lordship, I am appearing for respondent number 3, 6, and 7, Lordship.
3,
6, and 7, Lordship.
3, 6, and 7.
Lordship.
What is the correction? The correction in the cost title.
The name of the respondent number 8, Your Lordship, he has been implemented as by name here.
He has been implemented by?
By name, Your Lordship.
So you want to delete his name?
No, I want to implement him in his official capacity, Your Lordship.
All right, I'll allow it.
Lordship.
Yes. 46.
Lordship, 46.
Disposal. Disposal. Second half take naman diba? Likhi lo later. 46 na kalpana. Heard Mr.
A.M. Khan.
A.M. Khan, Learned Counsel for the petitioner. Stub also heard.
J. Bora, Lordship.
M.S.
J. Bora,
J.
Lordship.
Bora, Learned.
PNRD Department.
Learned Sending Counsel.
Lordship.
PNRD Department. Stop. This is an application filed by the applicant for correction of the cost title in the instant writ petition, in the accompanying writ petition, being WPC number 1369/2024 by inserting / correcting the name of the respondent number 8 as within quotes the President of Water Users Committee, Siltoka PWS's Dingdinga Post Office Dingdinga, FS Fakirganj District Dhubri, Assam. Close the quotes. Instead of Johirul Islam, President of Water Users Committee, Siltoka PWS's Dingdinga, PO Dingdinga, FS Fakirganj District Dhubri, Assam. Yeah, stop. Mr. So-and-so submits that the name of the respondent number 8 has been inadvertently typed in the cost title of the writ petition, and accordingly the present application has been necessitated for correcting the same mistake. Stop. MS so-and-so has no instructions to object to the said prayer. It appears that an inadvertent, it appears that the name, it appears that respondent number 8 has been inadvertently errate in person in the accompanying writ petition, and hence this court is of the considered view that the correction sought for is warrants to be allowed. Accordingly, it is directed that the petition allowed. Accordingly, the name of respondent number 8 be corrected and inserted as so and so instead of as so and so in the cause title of the accompanying writ petition. Let an amended cause title be submitted to the registry for doing the needful disposed of.
Please, Lordship. Lordship, yeah, with regard to item number 41, Lordship, I was in another court, Lordship. Apology, my Lord. In another court.
It's already passed the order. Yes, call the list.
47.
May I please, Lord? Lordship, service is complete. Kindly
97
peruse the
days
office
delay.
note. Kindly peruse the office note dated 16/7/2024, my Lord. Service is complete in all the respondent, my Lord. By the service report. Please, Chairman.
You are appearing for?
For Lordship, respondent number 2 on behalf of my senior Lordship.
My Lord, limitation is barred by only 97 days, my Lord.
But what about 5?
16, my Lord.
Okay, 5 also received.
Received, my Lord. Last line of the, my Lord.
4 also was not at home and was instead received and signed by his mother. Yes. How many days delay? 97?
97 days only.
Where is your explanation?
My Lord, we have all explained in para 4, 5 and 6, my Lord.
You have any objection?
No, Lordship.
Para?
Para 4, 5 and 6, my Lord.
Your para 4 and 5 is same.
Yes, my Lord. Details are explained in para 5, my Lord. That's why, my Lord.
Like 47. Heard Mrs. Mrs. L. Sharma, Learned Counsel for the applicant stroke claimant.
Insurance, my Lord.
Applicant stroke appellant.
Yes, ma'am.
Also heard Mr.
A.R. Das. A.R. Das. Lordship.
A.R. Das for respondent number 2. You are claimant?
No, Lordship. Insurance company.
There are 2 vehicles, my Lord.
It appears from the office note dated 16/7/2024 that service in respect of the other respondents, i.e. respondent numbers 1, 3, 4 and 5 stands completed. Stop. However, none appeared today when the interlocutory application for condoning the delay has been listed before this court. Stop. This is an application under section
5
of the Limitation Act for condonation of delay of 97 days in filing the accompanying MAC appeal. Stop. Mrs. So-and-so, Learned Counsel for the petitioner, submits that the delay of 97 days for filing the accompanying MAC appeal had occurred due to the time taken by the head office
Divisional office.
Head office and the regional office
Okay, yes, my lord.
in deciding as regards filing the accompanying appeal. Stop. She accordingly submits that the aforesaid delay is only is due is
97 days.
procedural and therefore warrants to be condoned. Stop. Mr. So-and-so fairly submits that he has received no instructions to object to the condonation prayed for in the interlocutory application. Stop. I have given my prudent consideration to the arguments made by the learned counsel for the parties and have perused the materials available on record and the explanation averred in the present interlocutory application for condoning the 97 days of delay. Stop. Paragraph 5 to paragraph 6. No. Paragraph 5, right?
Yes, ma'am.
Explanation?
Yes, ma'am.
4. Paragraph 4 to paragraph 6 of the interlocutory application is reproduced here under for ready reference. Quote unquote, A to A, page 5 to 8. Apparent that the said delay of 97 days had occurred due to the time taken by the authorities to prefer the appeal, and as such the same appears to be sufficient. Stop. I am of the considered view that the explanation forwarded by the applicant appellant is sufficient and bona fide, and as such the delay warrants to be condoned. Stop. Accordingly, it is provided that the delay of 97 days in filing the accompanying appeal is condoned. Stop. Let office to register the accompanying appeal disposed of. Ending here,
48.
Wait, please, Lordship. Lordship, the service is complete in this case. Lordship, can you see office note?
223 days.
223 days.
Service is complete.
Lordship.
Yes, you are for?
I am for explain number 1.
Any objection?
No, Lordship. Although the delay has not been properly explained, no objection.
When did they receive? May 24.
23.
Huh?
May 23.
23 already, though. These are the reports.
Oh.
Where have you got 23 days?
Oh, no, sorry, Lordship. They have received the judgment of the land. Yes.
Yes, which paragraph?
Lordship, paragraph 3 and 4. More specifically, paragraph 4, Lordship. The claimant petitioner is a physically disabled person, Lordship.
Physically disabled person?
Lordship, I have annexed the copy of disability certificate.
Okay, then. Financial problems.
Financial problem also, Lordship. He has lost his earning capacity.
Okay. This is 223 days. Heard Mr. M. Talukdar, Learned Counsel for the applicant claimant. Stroke claimant. Stop. Also heard MS D. Das Burman. D. Das Burman for Learned Counsel for respondent number 1. Stop. As per office note dated 11/7/2024, service in respect of the other respondents, i.e. respondent number 2 and 3, stands completed. Stop. However, none appears for the aforesaid respondent when the matter was called today. Stop. This is an application. That paragraph over 4, 5, 6. 4, 5, 6. আৰু এখেতৰ petitioner যোনটো reason কৈছে সেইটোত ক'বা that delay occurred due to the applicant being a permanently disabled person and due to his financial conditions. He, right? He or she?
He.
আৰু মই apparent বুলি যে কৈছো that কৈ দিবা apparent that due to financial difficulties and health conditions delay has occurred. All right. Disposed of.
49.
189 days.
Lordship.
Service?
The first time it is out.
First time. Then I'll issue notice. Heard Mr. J. Kalita, Learned Counsel for the applicant claimant.
Insurance.
Insurance. Applicant stroke appellant. This is an application seeking condonation of how many days delay? 189 days delay in filing the accompanying MAC appeal. Stop. Issue notice, returnable 4 weeks. Steps by registered post within the course of the day. Lists after 4 weeks on any date we fixed by the registry.
Right.
Right.
May I please, Your Lordship?
Yes.
Your Lordship, applicants are the claimant and also
First time?
No. Your Lordship, this appeal
No,
has
this
been...
matter has come up for the first time.
No.
But there is no order here.
Yes, this IA has come up for the first time.
So this is what the court is asking.
I'm sorry.
If the IA has come up for the first time, then notice has to go.
Your Lordship, in this case, perhaps notice is not required.
What are you seeking
Your Lordship,
in this application?
During the pendency of the appeal, the insurance company has deposited the awarded amount before the learned tribunal. So already the LCR has been called for, and LCR has been received by this registry of this honorable court. So without the LCR, the payment cannot be disbursed in favor of the claimants. So my prayer is that the LCR may be resent with a further direction to send back immediately after.
Main case to asani. LCR yet is said. No, main case.
I have filed the appeal for enhancement of the awarded amount.
No, but LCR must have been, LCR was called for.
No, case was fixed for hearing. Main case was fixed for hearing.
Correct. And in the main case, the LCR will be required.
Yes.
Then?
Your Lordship can pass an order directing that tribunal to resend again after immediately after releasing of the disbursement of the payment. I have prayed, Your Lordship. My prayer.
I'm posting this IA next week. Just pray for list this matter next week on any day. You want a particular fixed date? On such and such date. Next.
Oblige, Your Lordship.
We're hearing Nikki. Yes. Regularization of service.
No, no, no.
No.
It is regarding family pension.
Family pension.
Yes.
Yes.
My husband was a initially
You have
appointed.
not filed your reply.
What?
You have not filed your rejoinder.
Or no.
You don't want to. There are affidavits in opposition file. If you do not file a rejoinder, we'll take those averments to be
Not
correct.
required.
Not required.
Not
Okay. Yes.
Yes, ma'am, my husband was initially appointed as master worker in 17981. Subsequently, he was upgraded as WC Sokidar in a vacant
Work charged.
work charge in a vacant sanction post from 8896. From 8896.
1991, he was first engaged as a master
Master
role.
worker.
And in 1996,
Yes.
upgraded to as work charge.
Work charge.
Yes.
Then he expired on 15/5/2012.
2/11/11.
My lord.
He passed away on 2/11/11.
Passed away on 15/5/2012.
Where do I get that date?
No.
What is the date of the expiry date?
Expiry date is
because in the order of this court it is mentioned at 2/11/11.
Yes.
Yes. When did he die?
Date of death is 2/11/2011.
Exactly. So I was pointing it out, and you were saying some other date.
Yes. Yes. Sorry. 2/11/2011. So at the time of his premature death, he has completed
15 years.
Altogether 30 years of service.
30 years.
Yeah. Including 15 years of WCP. And he was engaged against a vacant and section post.
All right, but the contention of Mr. Nayak was that he is not regularized. Is that your
Yes.
stand? Not regularized.
Not regular. Without regularization, husband of the victim is not right now.
Anything to show that if one is not regularized, then he will not be entitled for the pension?
Judgments are there. Today, Lordship, I apologize. Today, I am not.
You're not ready. All right, I will have it next week then.
Recently
As
one
prayed
judgment was
for by
there.
Mr. P. Nayak, list this matter for hearing. Any date on next week?
Otherwise, it's settled.
You have it on next week. Yes.
Made picture lots.
Yes, Mr. Chaudhary. Everyone is ready?
Yes.
This is selection.
Yes. Well, a very short point is involved. If your lordships would kindly take the writ petition.
This is item 52 and 53.
53, my lord. I'll have your lordship's kind attention to item 52.
Yes.
WPC 1680 of 2019. Now, what had happened in this case, my lord? 34 posts of finance and accounts officer / treasury officer were advertised by the Assam Public Service Commission.
How many posts?
34.
34.
Yes.
34 posts
of FAO, finance and accounts officer / treasury officer.
All right.
Lord, the advertisement is at page 23.
Yes.
Kindly see 20th of February 2018. The Assam Public Service Commission will hold a departmental promotion examination of the members belonging to cadre of Assam Account Service, Assam Local Fund Audit Service, etc. on the dates to be notified later on for filling up 34 posts in Class 1 Grade 3 cadre of Assam Finance Service, including the post of so-and-so. So basically there are 34 posts. Now we are not concerned with the other aspects. Then what had happened, my lord, at page 28, Lordships will see, my lord.
Yes.
This is the, my lord, notification dated 24th of May 2018, whereby the list of candidates selected for appearing in departmental promotion examination was notified.
This is the selection. This is for appearing in the
departmental promotion examination. Now, if your lordship would kindly come to a serial number. Yes. My lord, serial number 25 and 26 are the two petitioners.
All right.
And serial number 26, 27, 28, and 30 and 32 are respondents number 6, 7, 8, and 9.
26 or at page 28?
Next page, my lord. This is the rejected list.
Oh, all right, all right.
Page 28 is the
Yes, I
list
have got
who
it.
are eligible.
Now here serial numbers 1.
Serial number, my lord, 2.
2.
Serial number 3.
Yes.
Serial number 4.
Yes.
And serial number 8.
What about 6?
No, 6 is not. We are concerned with 6, 7, 8, and 9.
This is the reject list.
Yes.
Page 29.
Yes. Kindly see the remark why they were rejected, my lord.
Yes.
All are overaged.
Overage. Yes. They have been selected now.
Yes.
After this remark.
Yes.
Okay.
Page 30.
Yes.
This is 25th of June 2018. As per the order of commission, the following candidates whose candidature was rejected earlier due to overage for departmental promotion examination for recruitment to the post of finance and accounts officer, treasury officer.
This order on the face of it looks illegal. No reason has been given. Overage or was wrongly said overage. Nothing is mentioned. Are they overage or they are not overage?
They are overage. Later on the government.
Then how, if they are overage, how they can give it? Where is there an age mentioned in the advertisement, Mr. Chaudhary?
Yes, no, there is a government circulars are there, my lord.
Yes.
So they have exceeded those limits. There is no dispute on that. But let me just place the facts,
Okay,
my lord.
all right, all right.
Now, page 30. Now they say they can appear.
They are overage condon, lordship.
That will show, my lord, why this is wrong.
Condon by the government.
Now, my lord will kindly come to page number 32.
Yes.
The Assam Public Service Commission hereby declares today, the 21st December 2018, the result of the departmental promotion examination of members belonging to cadre of Assam Account Service, Assam Local Fund and Audit Service, Assam Treasury Service in Class 1 Grade 3 of Assam so-and-so. Now kindly see, my lord, serial number 1. No.
Yes.
Yes. 1 is my lord Boxi Gulam Muhammad. Then 2 is Sandeep
Who is
Nandi.
he? 1 is respondent.
Yes, private respondent.
9.
R9. Okay, then?
9. Last.
Then?
Serial number 2 is R6.
Serial number
R6.
2 is R6, my lord.
Okay,
3
then?
is R7.
3 is R7.
All
And
right.
serial number 6 is R8.
6 is R8.
All right.
We have the selected candidates whose age has been
Petitioner was not selected.
No. Now, my lord, will kindly, we filed a representation saying how you could have done. Now that I'm just placing the facts, I'll articulate my arguments little later.
Mr.
Yes.
Chaudhary, this notification is the result
Yes.
who have been qualified.
Yes.
Isn't it?
Yes.
In that departmental promotion.
Yes. Conducted by the APSC.
So in this, as per this list, petitioner is not qualified.
No, I'm not qualified.
All right. Yes.
Now, admittedly, my lord, they were rejected. Now, subsequently, they were made eligible. Now we say this so-called.
But Mr. Chaudhary,
Yes.
I'm sorry to break your flow, but situated with the page 32.
Yes.
You are not qualified.
Yes.
Then how are you aggrieved?
No, my lord, if these people are not there, then?
No, departmental in the departmental
No, my lord.
examination.
I participated in a selection process. Now they are not selecting people who are otherwise eligible. We say they are selecting people who are not eligible. Why I have been rejected? There are only 9 people have been admitted. So there are other aspects to it. Lord, will kindly allow me to place it.
All right.
Yes. Because I am also a reserved category candidate. My lord will kindly take our affidavit.
No.
Affidavit by the Public Service Commission. It starts from page 36.
Yes.
My lord will kindly come to page 47.
Just a minute. Affidavit, 2 affidavit in opposition.
Yes, affidavit in opposition filed by the Public Service Commission.
Yes, I got it. 3,
3,
4,
4,
5.
and 5.
3,
Yes.
4, 5. Yes.
Passmark 65 into what to do.
Page 47.
Yes, page 47.
Yes.
Yes.
Kindly see, my lord, list of candidates rejected for appearing in departmental promotion examination for recruitment to so and so. So serial number 2, 3, 4, and 8 are the respondents. 6
This
to
is
9.
that same list.
Same document. Yes.
Overage.
Now, my lord will kindly come to page 50.
Yes.
Now, this is a letter by government to the Public Service Commission. Relaxation of overage for appearing in departmental promotion examination. With reference to the subject cited above, I am directed to inform you that below mentioned applicants have applied for age condonation to Finance Establishment Department for appearing the departmental promotion to the post of AFS, grade class 1, grade 3 there. So these are the persons. Now they are by what extent they were overaged, that is also indicated. Government therefore considers that the cases deserve relaxation of overage in the light of Rule 20 of the
What is
Assam.
Rule 20?
That service rule, my lord.
Yes. What does it say?
Yes.
A power exists.
Yes. Well, this is a general power of relaxation. It has nothing to do with age. Age is prescribed by, my lord, some other executive instructions. Where governor is satisfied that the operation of any of these rules
Which
causes
rules?
undue hardship
in these rules, the age is mentioned.
My lord.
In
No.
this rules, the age is mentioned.
No.
No. Then this relaxation will only be in case of these rules, right?
Yes.
Only in conditions of service.
Only qua condition of service, my lord.
How can age? Are there any authorities for condoning age?
No.
Age.
My lord, age relaxation is there. Government of Assam has issued executive orders in terms of which it is being done. This is
But
not
that
the
has
authority.
to be pre-advertisement.
Lord,
The condonation of age. You want water?
I'll have it. So, my lord, now government is proposing for age relaxation. Now, my lord will kindly come to page 51. Now, my learned friend says government has relaxed the age. Kindly see page 51. With reference to your letter on the subject cited above, I am directed by Commission to say that the Commission regrets its inability to accept the candidature in respect of Sandeep Nandi, Viraj Sharma, Mrigan Bora, and Boxi Gulam Mohammed and Sri so for appearing in departmental promotional examination mentioned in terms of government letter dated 27/3/80 regarding upper age limit for the state government services, as the same was held invalid by common judgment and order dated 3/8/2015 passed by the Guwahati High Court in WPC number so in connection with age condonation. What had happened, my lord? This 27/3/80 is a notification issued under Article 162. Now, what had happened, my lord? Prior to this, there is an 309 order of 1955. So once the field is covered by 309 order or rule, then Lordship knows executive instructions cannot be issued by invoking 162 power. That is why this in this judgment, that is 3/8/2015, passed in WPC 845 and all these cases, it was held that that notification is bad enough. So therefore, my lord, I'm sorry. Therefore, APSC said we cannot, relying on 27/3/80, we can relax the age. So, my lord, APSC has taken a stand, perhaps quite rightly. Now, my lord will kindly come to the next piece. These are all arm twisting. Page 52.
Page
52.
Yes.
Now, government is now again writing to the Public Service Commission. With reference to the letter on the subject cited above, I am directed to inform you that Finance Establishment Department has sent the application of one accountant and 5 senior accountants in the matter of granting age relaxation for consideration of Public Service Commission. Assam Public Service Commission is requested to reconsider their application in the light of Rule 20 of the Assam Finance and Service Rule in order to make them eligible to appear in the examination. Since no departmental promotion examination was conducted between 2011-2018, this has the approval of the Finance Minister. Hello, Finance
So
Minister.
APSC has already said it
We
cannot be done, but again,
Government
the
says
government
invoke
will
Rule
reconsider.
20. Rule 20 is a power, has nothing to do with age relaxation.
Nothing to do with
So,
age.
my lord, is arm twisting. That's what I'm saying. Now, government says, now the then Finance Minister, my lord, says, you invoke Rule 20. And, my lord, these officers are also very smart nowadays. Why they will take their own responsibility. So, they refers to, my lord, so and so, so and so, so and so. Then, my lord, will kindly come to the next page. Page 53.
Now APSC has.
And now APSC has. Now, my lord, will see examination was scheduled for 29th of June and 25th of June they were made eligible.
This is the same notification you had
Earlier.
shown earlier
Yes,
from the
yes.
petition, correct?
Eventually, at page 54, my lord, they were all selected. Now, this is not the issue, my lord. There are other issues also.
But this is one of the issues.
One of the issues.
Now, before we go to the other issue, here from the affidavits and that whatever has been filed, anything has been shown as regards how APC has reconsidered it?
No, that their records will say, but this is their
because
affidavit.
that is also material.
Material.
Because that document at page 16
Yes.
is very clear as why they have.
They have given reason,
They have
assigned
given a
reason.
reason. Now, it was sent back to
Now,
them.
if they went by the request of that contained in that letter of the government, then they must dispel.
There has to be some reason.
Yes,
it
yes,
cannot
some
be done
reason.
mechanically.
Yes.
That
Now,
has to be shown. So you be ready with it. If you have
Now,
it, very good.
the second ground of challenge. Now, Milord will kindly come to page 55.
1 second, huh?
প্রথমতে যে এই যে 80 টি যে লাগিয়েছিল
Yes.
Milord, before I take your lordships to the other part, Would your lordship kindly take the copy of the rules which you have given just now?
Yes.
Difficulty is not paginated here. My lord, in that copy of the
Yes,
rules,
rule.
yes, 3 pages from the end, my lord. It's part of the
11,
schedule.
Indian financial system.
Yes. My lord, the heading is yes. Last 3 sentences.
Yes.
Time allotted for each paper will be 3 hours. Maximum mark for each paper will be 150.
One second, Mr. Chaudhary.
Yes. In fact, that's
Yes,
Indian
I got
financial
it.
system only.
I got it.
Last.
Time allotted for each paper will be 3 hours.
Maximum mark for each paper will be 150 and minimum pass mark will be 80 or as may be determined by the government, schedule 3. So my lord, as per the rules, the minimum pass mark is 80.
Yes.
Now my lord will kindly come to the affidavit filed by the APSC. Please come to page number 55.
One second. Minimum pass mark.
Yes. The rule prescribes 80.
And this is rule 11.
Yes.
Okay.
Schedule to that.
Now,
page 55 of the affidavit of APSC.
Yes.
Now, this is an office memorandum dated 6th of June 1969, issued by Government of Assam. As per provision made in the last para, below Group 2 in Schedule
65.
2 under Rule 7.2 of the Assam Financial Service Rule 1963, relating to determination of pass mark for departmental promotional examination for recruitment to Class 2 of the Assam Finance Service, Governor is pleased to determine until further order that minimum pass mark shall be 65. So, my lord, rule was made 65. This is not an amendment, mind it, my lord. This is not an amendment to the rule. It's an executive order. I'll come to the validity of it, my lord. Now,
and this financial service rule, these were made under
309.
But it doesn't say here. These rules shall be called the Assam Financial Service Rules 1963.
I think, my lord, the gazette must contain this. It's
Something
a type copy.
because
Yes.
this doesn't indicate.
Yes, yes. No, lordship is correct. Now, my lord, will please come to page 56.
Yes.
Please come to para 6.1.
Yes.
This is a communication by APSC to my lord, Government of Assam in the Finance Department. Please come to 6.1. The examination carried 300 marks consisting of 2 papers comprising 150 marks each. Altogether, 27 candidates took part in the said examination. The commission, on the basis of marks obtained by the candidates, prepared the merit list and found that only 5 candidates got pass mark and above. That is, my lord, 130. That means 65, not that 160. The pass mark was based on Finance Department OM dated 6th of June 69, that is, my lord, at page 55, which postulates that minimum pass mark in each paper will be 65. The result was placed before the commission, and commission in its meeting held on 19/12/18 decided to award grace marks and accordingly fixed the benchmark at 120. Those who got 120 will get grace marks of 10 to come out successful. Accordingly, results were prepared and finally 9 candidates could be declared to have passed the said examination, including 4 candidates with grace marks. That means, my lord, out of 9, 5 must have passed out on their own. We really don't know whether these 4 who got the advantage or benefit of grace mark also includes respondent numbers 6, 7, 8, and 9. That APSC will have to clarify. Now, the position in law is very clear, my lord. 309 rule is holding the field. It says the minimum pass mark is 160.
Yeah, 160 or 80?
80 is equal to 160 in 2 paper, my lord. So 80, let us take it 80. Now it cannot be made 65.
So this minimum pass marks, which earlier was prescribed as per this rule to be 80, has been brought down to 65.
65. So in 2 papers, my lord, therefore it will be 160 or 130 as the case.
And there is a doubt.
So how many papers are there?
2 papers. Now, my lord, while carrying out amendment,
And in each paper, it has to be as per this 80.
and by that page 55 executive order, they brought it down to 65. Now, my lord, apparently 5 candidates out of 9 who were selected, they must have passed out on their own. That too 130, not 160, my lord. And the other 4, maybe it may include 6 to 9, may not include. That we are not privy to that. But the fact of the matter is, my lord, nobody has got 160. Now the issue is whether this is permissible. My lord, my first submission would be, when the field is covered by 309 rules, by executive instructions, you cannot tinker with it.
No, but where otherwise can we get this?
Yes, my lord. Subsequently, there was amendment which were carried
because
out
the,
under
the
309.
rule that you have given to me
Yes,
does
yes,
not
yes.
indicate. Oh, it is there. Published with a notification 28/58/42 dated 21st January in the Assam Gazette.
Yes, technically include, my lord. There is no doubt. Because subsequent amendments also, my lord, Gazette says under 309.
Where is it?
Yes.
There is no dispute that these are 309.
Yes.
Yes, there is no.
There is no dispute. It's an admitted position. Yes.
Now, my lord, on that proposition, I would like to rely upon 2 judgments of the Supreme Court regarding that notification of my lord 69. It is judgment to that. My lord, will kindly have 1979 4 SCC 507. এটা আয়ু জাজমেন্ট আছিল নহয় একটা নাই না নিকে যে এইটো পইণ্টতে এনিৱে yes my lord will kindly come to para 25.
Mr. Chaudhary, just one second.
Yes.
I think I had seen Mr. Soronia is gone. Otherwise, I don't think this matter will take some time.
Yes.
So item 54, you can have it on another date. Did 54. Mr. Soronia, this matter is going to take some time. So your matter any date next week. All right. Due to paucity of time, hearing. All right.
Yes.
If you want a particular date, inform. Yes, Mr. Chaudhary. This Nagarajan case, you are relying for the proposition?
Proposition, my lord, an executive order cannot override.
Right. That is quite settled.
Yes. Only one sentence at page 515, my lord.
Citation.
Citation is 19.
Yes, I got it. You said 2 cases. Which is the other one?
Judgment, my lord. I'll rely upon that 2015 4 GLT 103. Whereby, my lord, that 27,380 was set aside.
2015?
4 GLT 103.
4 GLT 103.
2015 4 GLT
103.
10.
All right. And in 17.9, which is
my lord, I will have para 25. Please come to page 515. Last sentence.
Yes.
And such a course is not sorry.
Yes.
My lord will kindly come to page 515.
Yes, I have it.
And such a course is not permissible. because an act done in exercise of executive power of the government, as already stated, cannot override rules framed under Article 309 of the Constitution. So, my lord, since the field was covered by the rules, so by that executive instructions, you could not have brought down the minimum marks from 80 to 65. Then, my lord, will kindly have the judgment, paragraph 39 and 40. Why that initial decision of APSC was correct. Subsequently, they succumbed to the
This
my lord
is what
request.
was mentioned in that
This
section.
Yes.
Paragraph?
Paragraph 39 and 40.
No, but that you will have to show me the reason for reconsideration.
Yes.
Because that is Yes, please.
Para 39 and 40, Miller.
Yes.
Following the above discussion, this court is of the unhesitant view that such a classification as made out in the impugned OM dated 27/380 cannot stand the test of Article 14 of the Constitution and is
What
liable
is
to
this
be struck down as
classification
such.
that they are talking here? It is about age relaxation.
Yes, age relaxation. Therefore, OM dated 27/380 is held to be invalid on both grounds as discussed above. Following the above conclusion, respondents are directed to consider the case of the petitioner for upper age relaxation on their individual merit. In each case, appointing authority shall consider the prayer for age relaxation in consultation with the APSC in the light of the discussion made above. The fact that the petitioners were allowed to appear in the selection process pursuant to order of this court shall also be borne in mind. And my lord, this was a direction in the facts of this case. Now, if your lordship would kindly come to regarding that OM. 1 second, my lord. My lord will kindly come to para 27.
Yes.
Para 27. A copy of the government notification dated 3/5/1951 could be traced to the General Handbook of General Circulars of Government. The said notification is quoted herein below. In pursuance of the provisions of Article 309 of the Constitution of India, Governor of Assam is pleased to make the following general rules regarding relaxation of age limit for recruitment to civil service or civil post in connection with the affairs of the state of Assam. Notwithstanding anything the contrary in the rules regulating maximum or minimum age of recruitment to a service or post in connection with the affairs of the state, the age limit may be relaxed in favor of any candidate or class of candidates only if in cases in which appointing authority is the governor or in other cases head of the department considers this necessary interest of fair dealing or in public interest. The rule head of the department means the authority who is declared to be head of the department for the purpose of fundamental rules and subsidiary and supplement rules made by the state government and includes a district and session judge. In case in which recruitment is made through Public Service Commission, the commission shall be consulted before the rule is relaxed. So, my lord, this is a rule framed under Article 309. So, you could not have had that 27/3/1980, whereby you gave this power. So, this Honorable Court says the classification which you have made based on 27/3/80 is bad. Therefore, in an individual case, if it is required in the interest of fair dealing or in the public interest, yes, government do have power. And in cases where the recruitment is to be made by Public Service Commission, then relaxation has to be done in consultation with the Public Service Commission. Now, Public Service Commission has taken a stand qua this very notification, this judgment. Now, when it comes to you, overriding or reviewing your own decision, then you must come up with some answers which should be palatable to this honorable, which should be acceptable to this honorable court. Now, therefore, this recruitment process suffers on account of two infirmities, my lord. Number one, this relaxation was given irregularly. And secondly, my lord, this mark, in making the selection, the prescription of the rule was violated. And my lord, the petitioner is a reserve category candidate. As a reserve category candidate, you could have relaxed in our case also. There were posts. And I participated in the selection process. So therefore, my humble submission is, my lord, if the consideration by APSC does not inspire your lordship's consideration, the logical conclusion is, my lord, the selection has to go. The Supreme Court has now said, my lord, even if you work for 10 years, doesn't matter. If your entry into the service was not in accordance with the rules, then there will be no equity would be recognized by the court.
That is in that illegal appointment case.
Yes, my lord.
2013.
I'll give that citation, my lord.
There were 7 posts advertised for STP. However,
See, as far as the first ground that you are taking,
yes,
as of prima facie, it appears that you are right, because that relaxation that they are showing, first of all, that doesn't say about age, and APSC had taken a decision,
and rightly,
which appears to be correct, as you're saying. However, the finance, though that they have referred, that letter, I think some minister is also mentioned.
Minister.
Yes. That says you reconsider. In terms of Rule 20.
20. Rule 20 is neither here nor there. You can't do.
Whatever. But after that, what happened? Nothing seems to be on record.
Even in their affidavit.
The affidavit addresses
I'm reading only their affidavit, my lord.
No, does the government from the have this
said
anything?
They only say
what happened from the stage of that letter to the issuance of the
they're very guarded, guarded response.
But that is the most important, because what has happened? Why have they changed their mind?
Maybe if they have good reasons,
Correct.
if they come up with that, if it is acceptable to the honorable court,
have to come out.
Yes.
And Rule 20, otherwise on the face of it, is not applicable.
Not applicable.
So how they have done it, that is what is required.
So they'll have to show me.
That is why I'm repeatedly asking. You may have genuine reasons, I don't know, but that has to come out from your records, not some after kind of a statement. It has to be at that time, before you have taken that decision. On what basis, what materials have you taken into account before reconsidering the case? That has to come out. In fact, that's the first thing that this court would like to see. As far as the first point is concerned, and as far as the second point is concerned, that mark from 80 to 60, how have you done? Because it seems that is a 309, and admittedly by an executive instruction it has been done. Is that permissible?
I'll satisfy, Lordship. I'll try to satisfy.
But that is the second. First, you have to. The first hurdle is to show on what basis you have taken a decision. Anything more to add, Mr. Chaudhary? Have you finished?
No, my lord, I have finished.
Yes.
My lord, another aspect, just on factual part, my lord, there were 10 reserve category posts, 3 for SC, 7 for STP. Only 2 were appointed. And when you have brought it down to 120, why not to 110? Why not to 100? How can you selectively bring it down?
But first hurdle they have to cross is this.
Yes. Why they change their view?
Because it looks you have reviewed your own decision, correct? Recalled your own decision. Now, if you have reviewed, you are aware on how you will do it. There has to be something which must have come to your notice that there's a error apparent on the face. There has to be something, correct? Now, what is those materials that are available to you? On what basis have you taken that decision? Please show that. I see you are taking out a book. Your book will not help.
No,
First, you show me your case.
Lordship, my submission would be based. I will try to satisfy from this law, Assam Financial Services 1962, Rule 6, Lordship, promotion. Lordship, that power of relaxation is vested to the government, not by our recruitment agency, Lordship. We are a recruiting agency under the Constitution of India, Lordship. And it is the recruiting department, Lordship, which they want, Lordship. First thing. So, promotion, may I read, Lordship? The promotion shall be subject to following. All vacancies in the grade 1 and grade class 1 shall be filled up by promotion by selection to the officer belonging to grade 2 and class 1 cadre. All vacancy. Lordship, I am just directly coming to proviso, Lordship, last proviso. Provided further that a member of the service shall be promotion to satisfy the following conditions. That a member of a grade 2 and class 1,
Where?
that last proviso of rule 6, Lordship.
Rule?
Proviso.
Proviso to rule?
6, Lordship.
Okay. Yes.
Provided further that a member of a service shall for promotion satisfy the following conditions. A. That a member of a grade 2 and of class 1 or a member of class 2 has rendered at least 4 years of service in respective grade or class, as the case may be, on the 1st January of the year of recruitment. B. A member belonging to the cadre of divisional accountant and auditor does not cross 50 years on the 1st January of the year in which departmental examination under Rule 7.2 is held. And
you are Mr. Gogoi, na?
Dr. Lordship. PP Dr.
Doctor.
Lordship.
Your name is not there.
We are the standing counsel after that filing this case, Lordship.
A Doctor.
Lordship. PP Dr. Lordship.
PP Doctor. Mr. Datta, where is the power for relaxation here?
Lordship, let us come, Lordship. Here, Lordship, this 50 years is prescribed under Rule 6, Lordship, and Rule 20, Lordship.
What
relaxation.
50 years have been prescribed?
And
it is a member belonging
to the cadre of divisional accountant and auditor does not cross the limit of 50 years on the 1st January of the year in which DPC under Rule 7.2 is held. In our case, DPC was held under 7.2, Lordship. And it is a gazette innovation and so and 5 years service. Now, Rule 20, Lordship. Relaxation.
Rule
20. 20, Lordship. Where the governor is satisfied that operation of any these rules causes undue hardship in any particular case, he may order to dispense with or relax requirement.
Yes.
Of that rule to such extent and subject to such condition as he may consider necessary for dealing with case in a just and equitable manner, provided that the case of any person shall be dealt with in any manner less favorable to him than the provided by any this rule. So any rule, Lordship, it is up to the governor, it is the government to relax any rule if it is undue hardship to implement that rule, Lordship.
So how will that relaxation be
Now,
executed?
Lordship, that the communication.
How will the relaxation be effected? How will it be executed?
It is effected at the government level, Lordship, not at
how? Because these are 309 rules.
It is not 309 related to, Lordship.
No, the
rule is but relaxation.
The Assam Finance Service Rules 1963 is a
yes,
309 rule, correct?
Yes,
now under this rule, Rule 20 provides a power to relax. Now it says whose satisfaction?
At the satisfaction of government, Lordship.
Where the governor is satisfied.
Governor satisfied, Lordship.
Correct.
Yes.
So therefore there has to be a
Lordship.
Some rule.
Yes. At the level of Lordship, government, Lordship, not at our level, Lordship. And now, Lordship, I'd like to bring your
but
Lordship.
How are you saying that it has to be at the level of the government?
Because APSC has no power to relax.
No, not that. First, come to Rule 20. Let us first understand it.
Yes,
I have a difficulty in understanding your
Lordship.
Submission when you are saying at the government level.
Yes.
Because Rule 20 says where the governor is satisfied that the operation of any of these rules causes undue hardship, or in any particular case, he may order to dispense. He may order.
Lordship.
So where is the order of the governor?
Lordship, that will be clarified by the government, Lordship.
Because this talks about governor, but what I remember was that was shown is some communication from the state government.
Yes, Lordship.
Now governor is not state government.
No, Lordship, as per a rule of executive business, as Lordship would be aware, Lordship, and my senior friend is more clear in this point, Lordship, subject to correction of both, Lordship. As per rule of executive business, power of state is executed in the name of governor, Lordship. So governor's power will be exercised by the state government. Lordship.
This appears a little bit of.
Now,
I
Lordship,
don't know. I
page
have to be.
22.
No, my lord.
Mr. Chaudhary,
No,
please.
no, I'll explain the position,
Yes,
my lord. Governor is a constitutional governor. Under the scheme of the constitution, my lord, there are certain situations when the governor act on his own discretion. For example, sixth schedule, then recommending president rule, and 2-3 other situations. Otherwise, governor, as we understand, is a constitutional governor acting on the aid and advice of the Council of Ministers. My lord, yes, governor can be safely referred to as the government. But going by page 56 letter of the APSC, it is the APSC who has taken the decision to condone, my lord.
No,
then my learned friend is arguing.
the letter which was sent to APSC.
My lord, the government said reconsider. Then first government will have to relax.
That letter can be said to be a letter under Rule 20.
No, they say they're asking APSC
to
invoke Rule 20 and give the relaxation.
Now, where is the order of Rule 20? Who has relaxed?
Number one, cannot be, and secondly, it is the government who has to.
So therefore, it appears prima facie there is no relaxation under
yes,
Rule
by
20.
the government.
There has to be an order.
Yes. My lord, only once government relaxes, then only APSC can touch the file.
Now, Lordship, page 52, Lordship.
Okay.
After that communication with the government, Lordship, that this letter we have received on 20 June 2018, Lordship. Page 52.
Page
52 of my affidavit. Got it. This was from the Finance Department, from the Joint Secretary Government of Assam to the Secretary APSC.
What does it say?
Lordship, relaxation of overage for appearing in the DPC for recruitment to the FAO and Treasury Officer in Class 1 Grade 2 cadre so. Which refers to the letter on the subject cited above. I am directed to inform that Finance Department has sent the application of 1 accountant and 5 senior accountant assistants in the matter of granting age relaxation for consideration of the Assam Public Service Commission. Assam Public Service Commission is requested to reconsider the application in the light of Rule 20 of the Assam Financial Service in order to make them eligible to appear. Lordship, the reason has also been cited by the government.
But Mr. Datta, where is that relaxation? Who has relaxed? Where is that order?
Lordship, that
have you understood?
Yes, yes, I got your point.
I
got your point.
This says it is asking the APSC that you are requested, you reconsider as per Rule 20.
Rule 20.
Right. Now, when you go to Rule 20, what does Rule 20 say? That the governor has to pass an order.
Yes.
Now, where is that order?
That order will have to be explained by the government.
No, but
this communication,
government of Mr. Nayab's affidavit is there. Has he brought that order on record?
And there is also one reason has been cited to the APSC, Lordship. Last sentence, Lordship.
Yes.
Since no departmental promotion examination was conducted between 2011 and 2018.
That's all right.
That is why the consideration.
See, till here it's all right. I've understood. Now, the question that I'm asking is under Rule 20, where is the order? Page 15. Which is this affidavit? 50. 50. Yes. 6 June.
6 June.
6 June. Yes. Hence, prayer petition are being sent herewith for your consideration. So, Under Secretary Finance have sent it to APSC for consideration.
Last 2 paragraphs. Government therefore considers that the cases deserve relaxation of.
Where are you reading? Government therefore considers that the cases deserve relaxation. Overage in the light of
Rule 20 of the Assam Finance. Hence, the prayer petition of the above mentioned incumbents are being sent here for your consideration in terms of question with department.
But this is done on 6 June 2018, correct?
Yes.
Now you come to the next page, 15 June 2018. What does this say?
Here, Lordship, Finance Department convey.
No, in what does 15 June 18 says? Reference, you see, this is that 6 June 18 you are referring. Correct.
We referred
With reference to that, APC has taken a decision and they have rejected.
No,
APC was instructed to consider the cases of relaxation in terms of the OMDD.
I'm getting your point. You are trying to say that the 6 June letter is itself the order under Rule 20. That is what you're trying to show, correct? According to you, this is the order.
Lordship, one point I like to clarify, Lordship.
1 second. Now, page 15 doesn't inspire confidence of this court. You see, no, Mr. Nayak, kindly see Rule 20 once again. Kindly see. Relaxation cannot be done as a matter of course. Correct. What has to be there? Some application of mind, and in case of what is given there, where the governor is satisfied that the operation of any of these rules causes undue hardship in any particular case, he may order to dispense with or relax the requirement of that rule to such extent and subject to such conditions as he may consider necessary for dealing with the case in a just and equitable manner. Now, in page 15, from where can you show me that all these relevant considerations have been considered?
Article 154. The executive power of the state.
No, that is all right. Now somebody has to exercise this power.
Here the state government is
Correct. Now the state government has to do this.
Their application deserves consideration, and it can be considered in terms of the OMDD 27/3/2018.
So you mean to say now APSC is also governor?
No.
Then?
But this OM is already there. Office memorandum for relaxation of age is already there.
Where?
This is mentioned here 27/3/2018. 1980.
Sorry?
In the last paragraph, Lordship. Hence the prayer petition.
Where is that notification? 27/3/1980?
In fact, they consider their age relaxation. In
No, where is that? Where is that 27/3/1980?
It is not
is it available?
Yeah, available on.
So then this is a notification whereby the government laid down certain conditions for relaxation of age, which has been interfered in the judgment, Milord.
But I'm not sure if I have rightly understand all the entire arguments from both sides. But if I have correctly understood, Rule 20 is giving a power to relax. Till here, let us assume that the government has the power to relax the age in a given situation concerning promotion. Let us assume it is correct. Now, how that has to be done is also given in Rule 20.
Yes.
Correct. For that, there has to be reasons.
Some order.
Before that, order definitely, but there has to be satisfaction. Condition precedent is that
public interest.
That age which is prescribed is causing hardship. This is one of the, I think it is a condition which has to, it has to be there. Sine qua non. That it is causing undue hardship in any particular case, then he may order to dispense with or relax the requirement of that rule to such extent and subject to such conditions as he may consider necessary for dealing with the case in a just and equitable manner. So how the power is to be exercised is also given. Now here, admittedly, till now what is shown is page 15. Now page 15 is shown as if this is the order under Rule 12.
No,
correct?
page 15 on.
The case is completely different. So it is a completely different. Here the very simple issue is that how he is prejudiced that some age
Mr. Nayak,
has been relaxation to increase.
Mr. Nayak, I am not on that. Please try and understand what the court is asking also. Now, the court from the first, from the initially, the court was asking where is the order. Now, you are showing page 15, correct? And by showing page 15, you are trying to impress upon the court that this is the order under Rule 20.
Because for age consideration of relaxation of age, one office memorandum, one procedure is already there in that way.
So then you have it. I'll place it on Monday.
Why I'm saying, Lordship, this issue is not at all necessary, Lordship. for
How can it be
execution of
not
this case.
necessary?
Because
that is the challenge.
Even if case of some other persons has been relaxed, how the petitioners are visited is not. And he participated in the examination knowing fully well.
Mr. Nayak, I shall also come to that, because at the end of the day, all the issues has to be addressed, right? So, in fact, at the beginning, I had put that question also, correct? That how are you agreed? So those all might come. They might be all important as issues, but first and foremost, I need to be cleared where is the order, because your page 15 is it cannot be said to
No,
be an
50
order.
was
under
acted
the-
upon by page 51, APSC rejected it.
Correct.
Then the third case was brought up.
As of now, I don't see any order under Rule 20. Now, if there is no order under Rule 20, then that relaxation goes.
Two different. One Rule 20 is there already. And one OM of 27 with 1980.
That is not brought on record till now. Why? If you are saying that this is where from you are deriving your powers to relax,
So my friend is saying that it was relaxed under Rule 20. It can also be said that it was relaxed in terms of the OM dated
but by now this should have been part of the record then, isn't it? Because this matter is being taken up for hearing. Anyway, when can you have it?
Well, I think in this case, they have to produce the record wherefrom it must appear that government had relaxed the rule by invoking Rule 20.
Now and now they are trying to improve that argument, Mr. Chaudhary. They are saying not only just Rule 20. According to them, the relaxation is in this notification 27/3/1980.
No, my lord, because APSC has already said at page 51
Yes,
that,
but
that
Mr. Nayak,
notification
if
has
I
been
have understood him
interfered with.
correctly, he is saying it is 27/3/1980. Correct? This is your submission?
Lordship, my submission is that by page 50, Lordship, we have been asked to consider the candidates of those 6 candidates, Lordship, on two grounds. One is relaxing under Rule 20, and also on the basis of the OM that in 1980, Lordship. But OM in 1980 was interfered by this honorable court. That's why APSC has referred back the matter to the government that under this OM, we cannot relax the age.
And then later
But
they
then
say that now
they
you
have
do it
again
under Rule
communicated
20.
us that we are relaxing those days
Absolutely.
under
APC
20.
is absolutely correct, Mr. Nayak. That is how it has been proceeded.
On
Subsequently, in that letter, you have only mentioned is Rule 20, that reconsideration letter.
And in
Where is that letter?
page 52, Lordship. And in that letter, also reason was also assigned, Lordship. Why this candidate has
APC
been-
is requested to reconsider their applications in the light of Rule 20 in order to make them eligible to appear in examination. Since no departmental promotion examination was conducted between 11 to 18.
And there are vacancy, Lordship. So department was also facing crisis of manpower, Lordship, at that point of time. There would be the reason, Lordship.
Rule 20 is there. Rule 20 gives me the power to relax the age. But what are the universal procedure is to be adopted? That what has adopted that OM of 1980 is already
So
there.
if a power is given, that power has to be exercised in the manner it is given. But Rule 20, can you say this document of 17 is strictly in accordance with Rule 20?
That may be in otherwise,
Rule
Lordship.
20 indicates.
Lordship, in otherwise also, Lordship, the petitioners who could not secure the minimum marks, they have no locus to challenge. This is another limb of it.
Definitely. You see, right now it doesn't appear I can dispose this application today. So, in
Because
you that argument which you will make will certainly be considered. But as of now, there is some doubt as regards the order of Rule 20. At one point, Mr. Nayak was referring to the document at page 15 to say that is Rule 20. Then he says it's not Rule 20, but it's that 1980, which you have correctly clarified that that decision was there. Therefore, you could not, and you had rejected. Thereafter, they again send you back saying, no, you do it as per Rule 20. But before doing that, where is the order? Now you are doing it. You are APSC.
Yes,
you are not government.
No.
Correct.
That's it.
But if we go by Rule 20, it is the government who has to first relax it.
Because
where is that relaxation?
We are acting
government
on
has
their
asked you to reconsider. in terms of Rule 20.
No, in the first letter.
Mr. Datta, are you
Yes, I
following
got your
what I'm
point.
saying?
I got your point.
Nazir Ahmed's case.
I got you.
If a power is given, it has to be exercised in that manner.
manner.
All other will be forbidden.
Yes.
And this power is not even given to you. Where is the power to APSC to relax?
No, under yes, we cannot relax.
Correct.
Unless government has
Correct.
clarified.
So where has the government relaxed?
That
Government,
page 52, Lordship.
no, government in page 17 is asking you to reconsider.
Yes, sir.
So the government, in other words, is asking you to relax.
Or rather abdicating his authority.
No, they are actually page 52, Lordship. They have again sent back that to reconsider their candidature. Page 52.
52.
I am in page 52, Mr. Datta. Please read 52. Read the last paragraph. What does it say? Requested for
Lordship,
what?
Initially, page 50, Lordship.
Please read 52.
Lordship. Before that, again, I like to read page 50 again.
Yes.
That the government, therefore, last but one paragraph, the government therefore considers that the case deserves relaxation of the overage in the light of Rule 20. The decision has been taken to give you their relaxation under Rule 20, Lordship.
You see, Mr. Datta,
But
if you make that submission also, there is an answer from this side.
No,
because this is also not in terms of Rule 20.
Lordship.
Because in this, where you are reading that government therefore considers, prior to that, government must give the reasons.
It is up to them, Lordship.
No, it's not up to them. It is for them. It is mandatory for them to give that reasons. And those reasons has to appear in the document itself. Where is those reasons? It is, these reasons are condition precedent. They're sine qua non for the government to act under Rule 20. You can't be blowing hot and cold together. Once you are saying this is the one, then you say this is the one. But where is the order?
We have no business in this age relaxation. In the age relaxation matter, we have no business. It is up to the government.
Correct. Even this court is also saying that.
Just to, buttress the point, in Amarjyoti Sharma's case, a similar letter like page 50 order was construed by this honorable court as not an relaxation by the government. Similar letter was issued.
Where is that case?
Yes, madam.
Because even this court, I don't know, I may change my mind after hearing everyone
Yes.
But at this moment, I am not inclined to accept these documents as age relaxation under 20. Either that document at page 15 or document at page 17. And you cannot be playing hot and cold, because after 15 you said you had taken a decision because of that decision. You cannot do it. This is your stand.
Yes.
So you did not do it.
Kindly come to para 12.
In that page 50.
1 second.
1-2 Miller, para 12.
Yes.
However, even if we keep aside the profile of respondent number 7, the question to be answered is whether any relaxation of upper age limit was actually granted for the candidature of respondent number 7. Only document projected by respondent number 7, as also by APSC, suggesting finalization of age relaxation is communication dated 7/9/2009. I have carefully read this letter, and my inference is that this document does not grant age relaxation to the candidature of Sri Asutosh Kundu. This letter simply forwards the application of respondent number 7 to APSC as per his wording. It can at best first step towards the process of age relaxation under subpara 4 of clause 2 of OM dated so and so. The letter does not indicate whether appointing was, that is the point.
This is what I'm saying. These two letters does not address whether you have taken the case into consideration or not. Because first you will have to take it into consideration, test it whether the condition, that age that is prescribed is causing an undue hardship. Once you come to a finding, thereafter you will consider as how you will do it. But these has to be there.
Yes, Lordship is right.
Where are these? These
So
two letters
similar
doesn't
letter
show.
was construed by this honorable court as not
You've
relaxation.
understood, Mr. Datta, what I'm saying.
I got
You may have a case.
Yes.
But right now, those documents are not before this court. Records are not. So as of now, I am not inclined to accept these letters as relaxation under Rule 20. On that, I can set it aside and I can allow this writ petition. Because I'm absolutely not satisfied. They cannot be construed to be powers exercised under Rule 20. And the last document, that 20, says you reconsider as per Rule 20.
Yes.
How can APSC consider under Rule 20? APC is not the authority under Rule 20, isn't it?
Yes,
The government has to
Government has to
consider and then say that we have considered the case and we have relaxed it. Once the government says that, then you can act.
Yes.
But where is that order? Where they have said that I have considered, I have relaxed it for so and so reasons?
That I have, the APSC has transpired only from page 50 for the paragraph, that they have considered, then they deserve.
That cannot be. That consideration is not as per 20, because the condition precedents are absent. Then that order is illegal, null and void.
It is up to the court to do.
No, but
yes,
it is not just up to me, but the order itself shows if the condition precedent is not taken into account, then of course it will be illegal, isn't it? Yes.
And
let government produce the record.
and so far as the second round that my learned senior friend has taken,
We'll go to that later. Now you produce the records.
government will produce.
Have the Mr. Nayak. When can you have the records?
My submission will be Lordship will hear the entire case.
Because I'm hearing the matter.
Even there are things that record is necessary. Not record will definitely.
Mr. Nayak, this court will obviously hear all the parties before giving a judgment. But as of now, with whatever we have heard, whatever this court have heard, it appears that the stand has to be made clear. So the whatever is available here does not indicate. You have the records.
My only submission will be Lordship will hear the matter.
Are you suggesting that this court does not hear a matter and passes an order?
I am saying Lordship, if
Then-
your Lordship thinks, ultimately if your Lordship thinks that for adjudication of this matter, record is necessary, it will be definitely placed, Lordship,
This is what this court feels.
at this stage.
Of course, because you've heard whatever is being transpired. The pleadings does not indicate. Does it indicate? Or if you say that if your stand is to dispose this writ petition on the basis of this material, I can do it right now. In that case, this court is not satisfied. I'm giving a chance to the government to prove your case. Simple as it is.
My submission remains, Lordship, this issue of age relaxation is not at all relevant for adjudication.
All right.
That is not, it will be placed, Lordship.
Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. R. Singha, learned counsel for the petitioners. Stop. Also heard Mr. P.P. Dottal, learned counsel for standing counsel APSC, learned standing counsel APSC, and Mr. P. Nayak, learned standing counsel Finance. Stop. And Mr. Soen KJ Saikya for respondent number 7. During the course of hearing, it appears that the records of
My lord, the record or the decision-making process regarding age relaxation, we have the file.
The records pertaining to the decision making pertaining to the subject age relaxation in the matter be called for is necessary and essential for adjudication of the writ petitions. Stop. Let Finance Department produce the said records. Give a date, 2 weeks or on such and such date.
Also, we are keeping the matter for further hearing, you know.
For further hearing.
Deep reply.
We will stop.